is allowed, impugn judgment is set aside.
May I please, your lordship? With the consent of others, that actually join prayer, item number 12, lordship. Can you take up the matter in the first week of March, if possible?
It was on the prayer of both parties. Given it.
If possible, 12. 12 March. Obliged.
So this is the regular bail application, and earlier one time is rejected, your lordship. Actually, what happened, your lordship, on the dated 5/2/26, on that day, I have two matters, your lordship. One is the item number 16 and item number 17. And I have submitted before this honorable court, your lordship, of the same submission, your lordship. And the one is granted bail by this honorable court on the same grounds, same sections, your lordship. And the record also same, your lordship. And lordship, this petition was rejected, your lordship. And the page number 79 of the para number 4 and 5, your lordship, where the bail granted by this honorable court, BA number 3302, paragraph number 79, your lordship. Para number 4, it contended that there has been clear violation of the mandate of section 48 BNSS, which requires intimation of the grounds of arrest in writing to the family members, friends, nominated persons of the arrestee in as much as the said notice has been sent by the WT message, but there is no proof of service. Lordship. And number 5 para, a perusal of the WT message reveals that the same was sent by the OC July PS2, RK Nagar PS so and so on the date their arrest. It has been stated in the said message that the grounds of arrest has been mentioned in the said WT message. It also appeared that from that one of the petitioner has temporary address so and so, your lordship, Muhammad Ali Ahmed, and but as contended by learned counsel for the petitioner, there is nothing to show that concerned police station. Both of the police located within some had fake served copies of the said notice to the family, friends, and arrestee, lordship. And the same is in contravention of the direction of Honorable Apex Court in Bihan Kumar versus State of Haryana and another. And so, your lordship. Then number 6 is considering the bail above the prayer of bail is allowed. And lordship, where the bail was rejected, your lordship, of the paragraph number 89, sorry, page number 89, paragraph number 8. Page number 89, your lordship. Paragraph number 8. It is next contended that there has been clear violation of the mandate of section 48 BNSS, which requires intimation of the grounds of arrest in writing to the family members, friends, nominated persons of the arrestee, is in as much as the said notice has been sent by WT message, but there is no proof of service. It is admitted, your lordship.
Is contended. Don't you understand the difference between contended and admitted?
And lordship, there, paragraph number 9, your lordship. On perusal of the record, it is seen that a WT message has been sent by the OC Dilai PS Karbi Anglong, OC Lilong PS Thoban Manipur. It is addressed to the local police station, not to the relatives of the accused person, your lordship. And I have annexed one of the BA lordship of the paragraph number, page number is, your lordship.
Why don't you go on reading the judgment?
Lordship.
Why it was rejected?
Yes, lordship, but the same grounds, one lordship, one.
Why was this application rejected? Why don't you read that?
Lordship, in the paragraph number 10, Your Lordship, there have mentioned that Bihan Kumar versus State of Haryana and another reported 2025, so and so has held that grounds of arrest are required to be communicated in writing in the relatives, friends, nominated persons of the accused, and failure to do so may render the arrest illegal, Your Lordship. And Your Lordship, on the paragraph number 11, Your Lordship, at this stage, there is extremely important to notice is that the addresses to the relatives of the accused person show that they are residents of Manipur. Judicial notice of the fact has to be taken that at the time of occurrence, that is 18/8/25, Manipur was still a highly disturbed area with sporadic incidents of ethnic violence, and it could not have been very easy to serve such notices to the said persons within such a short time, and also to obtain proof of service. The decision of Bihan Kumar cannot be read as permitting of no exception regardless of the circumstances. Thus, use of term may would prima facie support this view. Therefore, strict compliance with the provisions of section 48 BNSS cannot be insisted. But Your Lordship, in where the bail
So
application
that is the difference between your two items.
not different, Your Lordship. That is also, they have also arrested on 37
Where are the residents
2025,
of?
and they are arrested on
Their
18
relatives are residents of which place?
same place, Your Lordship.
Please read your brief and come back. Learned counsel is not prepared with the brief. It appears. List the matter again next week.
Okay, sir. Notice has to go on the respondent. Allegation is under the POCSO, and then my lord, similar connected case is fixed on 23rd. CD has been called for. May it be taken up with AB 276/26.
Maybe 270.
23rd is it is fixed on 23rd, my lord. Connected case
Notice need to be issued along with so and so.
along with AB 276/26. Notice to the concerned police station. Obliged, my lord.
Respondent number 2, Colonel.
May it please your lordship. Your lordship, mediation will not serve any purpose here. So the matter can be fixed for hearing.
Everything is complete.
Yes, your lordship. LCR also received.
Submitted on behalf of the parties that the matter is not fit for referral to mediation. Is the matter for hearing? Yes, otherwise it is ready for hearing.
Your lordship. Please, your lordship, please, your lordship.
Yes.
I don't have any objection if it is
Who is the other side? You are for the insurance company?
lordship. I'm for the appellant.
Radhika Debnath.
Yes, lordship.
This is for what is this for enhancement?
Yes, lordship, enhancement.
Learned counsel for the appellant submits that since the matter relates to enhancement of the awarded amount, the matter is fit for mediation. Accordingly, is referred to the High Court Mediation Center. Parties are directed to appear before the mediator upon receipt of notice. List again after.
May I please, your lordship? I don't have any objection if it is referred to mediation.
I also. What is appearing? For the other side, no name is shown. Appears to be complete. All right, same order. Okay.
For respondent number 1 and 2, claimant lordship.
Please, your lordship, I am for the appellant. Don't have any objection if the matter refer to mediation.
There is a law point lordship.
The
It
law
is-
point may be involved, but if you agree, difficulty. You are-
So the law point is involved, it's jurisdiction. Appellant is count for the jurisdiction lordship.
Uh-huh.
Appellant appeal for the jurisdiction lordship. Count number 4 Roman. But you may kindly fix it.
Who is appellant? Appellant is insurance.
Yeah, insurance lordship. Case number 4 lordship, Roman 4 ground
Award was allowed in favor of the claimant.
lordship.
Para 4.
Page 4 lordship, Roman 4 ground. May I read lordship? Accident occurred Dolgaon. Therefore, there is a
I think that is just a formal ground. File anywhere, I think. There is no question of jurisdiction. Go to mediation. This is not an entertainable ground at all.
lordship.
Let's say model.
Much of it.
Please, your lordship. Lordship, I am appearing for. There is no scope of settlement, lordship, and already the case is in the hearing stage. So lordship may fix case for hearing after 10th of March, lordship, if possible.
Submitted by learned counsel that there is no scope for settlement through mediation. That is otherwise ready for hearing. List for hearing.
Authorized.
May it please your lordship.
My lord, this CRP IO, my lord, pending since long. It was filed in 2018 against one order. In fact, the case from the date of trial to the, my lord, second appeal, this petitioner could not appear, my lord. Before the trial court, appellate court, before the high court, nowhere he could appear, my lord. He was earlier not a defendant, but he was made defendant number 4A. Then, my lord, one notice was issued, but he did not receive the notice. As because he did not receive the notice, my lord, somebody else has appeared by using his thumb impression, by filing vakalatnama. Then thereafter, my lord, what happened? Subsequently, after, at the time of filing the WS, they did not appear, that party. Then, my lord, decree was passed. Decree went in their favor, my lord. Then, my lord, what happened?
What was the decree about?
Decree is regarding right, title and interest, everything, my lord. But this petitioner did not receive any notice from the court, my lord. But when at the last stage, my lord, when this execution case notice he got, my lord, then he.
So
with the
who
help
went on
of-
appeal?
My lord?
Who went on appeal against the decree?
No, my lord. He did not appear. Other side. Other advocate appeared. Now what happened, my lord?
No, was the decree appealed against?
Yes, yes.
Who went in appeal?
No, this other defendants, my lord. 1, 2, 3, these defendants. Now, my lord, in fact, main party is this petitioner. He is the main party, my lord, because he purchased the land. He has the sale deed. He was made subsequent party to this suit, my lord. What happened, my lord? This petitioner, after receiving this execution notice, my lord, he filed one petition before the trial court, execution court, to send this, my lord, Bhakalatama, all these papers to the FSL, my lord. That court, executing court, has rejected that application. Therefore, this IO is filed, my lord. My lord, this at page, my lord, 35. Page 35. That is the order, my lord. In the petition number.
Appellate court confirmed the decree.
Yes, my lord. Everything in their favor, because, my lord, he was, in fact, he was not, he was barred from appearing, my lord. He was barred from appearing. That's why, my lord, somebody else has appeared, made, my lord, ex-parte. Then, my lord, proceeded this appeal, then second appeal. This is the position of this petitioner, my lord. He has the sale deed, my lord. He could not appear, could not file his written statement, my lord. Now, this order against the petition under order 26 rule 10A, read with section 151, stating that opposite filed title suit number 32/2000 obtained a decree against him suppressing the summons suit when the civil ledger of the court went for execution of the decree. The petitioner for the first time came to know about the decree and immediately filed petition. But after going through the record, TS 2032/2000, the petitioner found that at the instance of the plaintiff, somebody appeared and engaged advocate in the name of the present petitioner, judgment debtor, but subsequently remained absent. The petitioner never appeared in the court nor engaged any advocate in his behalf, but the decree holder, basing upon the petition, now objected against the petitioner. Hence, it is necessary to examine the handwriting expert, those signatures in the petition and Bhakalatnama filed in the name of the petitioner in the title suit, and to ascertain the truth of the matter. Hence, the petition to consider the matter, the record, so and so, my lord. Last portion, they filed objection also, my lord. The main intention, page 36, my lord, first paragraph, second paragraph. The main intention of the petitioner is filing petition just to cause unintentional delay in executing the lawful decree. Hence, the prayer for dismissal of the petition. Peruse the case record, heard both sides. It is found that the petitioner Abdul Ghaffur is defendant number 4A in the original suit. title suit number 32 of 2000 on 12/9/2002, defendant number 4A appeared and filed petition and sought for time to file the written statement. This is on behalf of the petitioner, somebody else has appeared, my lord. But this petition, which was allowed by the court on 22/11/2002, was fixed for filing written statement by the defendant number 4A, but on so-and-so date, defendant number 4A failed to appear written statement, so the case proceeded ex parte against him since 21/11/2002. The defendant number 4A remained absent without step. The judgment and order passed by the learned trial court in title suit number 32/2000 was challenged in
we've
the
seen,
higher. This is the case, my lord. Now, the petition, my lord, is at, my lord, at page, my lord.
No, supposing your petition was allowed, the matter was sent to FSL and it came back with a report in your favor, then what is the role of the executing court at that point? Under what provision, what is it supposed to do then?
That's one matter, my lord. Because
What is the power of the executive
executive court
after?
has limited power.
So basically your case is that it is a decree obtained by fraud.
Yes.
So therefore a suit lies to set aside a decree obtained by fraud.
Yes, my lord, I have also advised, but since this petition is pending before the
I
honorable
mean, if
court.
you have filed a suit, then why this?
Yes. It's because they are not, they're so simple, and my lord,
They're simple, you are not simple, you can advise them.
this is the petition, my lord. Now, my lord, they also
See,
lost
you can't
FIR.
pursue two remedies at the same time. If you have filed a separate suit, then this does not lie. Otherwise, there may be conflicting decisions.
Now, my lord, what happened? Say already time barred.
Suppose we allow this. If you have filed a suit, how will the executing court entertain this application? Because the suit is pending in that regard.
Yes, yes.
That whatever is your claim, that is to be proved in the
By
suit.
the trial court.
Yes.
It can be done, my lord. Because FIR also lost against this, my lord. But since this matter is pending before the High Court, the police also not, my lord, willing to take up any
So
action.
we record your submission that a separate suit is pending and
Not
is-
pending, still not pending. I have advised, but they have not filed till this.
and we'll say this does not lie.
In fact, my lord, I have advised them to settle the matter outside the court. But this other side is demanding huge amount. My lord, they are not in a position to pay even 10% of that amount also. This is the thing. But otherwise, this petitioner, my lord, has the 4A, defendant number 4A, he has the, my lord, right title and interest over that plot of land because it's a purchased land, my lord, which is sale deed. So, this is the position, my lord. Now, we got this day order since filing of this petition in 2019, my lord. That's why, my lord, still, my lord, no decision has yet been taken. This defendant, my lord, otherwise not so healthy person, my lord. So, if your lordship allow this petition, then, my lord, actually this truth will come, my lord. Because somebody has appeared by reporting the court, my lord. A very serious concern, my lord. A very serious situation, my lord. Otherwise, if it is false, my lord,
Whatever be
everything
the
will go.
situation, you have to go as per procedure provided by law.
Yes, my lord. What happened, my lord? If your lordship,
Not a civil revision petition, it's not a mercy jurisdiction.
very limited. But, my lord, there is no way out, my lord, because
Way out is there. You ought to have filed a suit.
in fact, I advised at that time to file a separate suit because, my lord, they are too poor person, my lord.
That's okay. You are not on trial here. Counsel is not on trial. You are representing your client.
Yes, yes,
You can't say, I told him this and
yes.
that.
The fact, my lord. The fact, my lord.
Yes, respondent.
Yes, Lordship. Basically, the petitioner before your Lordship against ex-parte decree is questioning non-service of summons as well as wrong representation before the trial court. So what is the remedy, Lordship? That is why Order 9 is there. Decree is passed against them ex-parte, that is ex-parte, Your Honor. Firstly, and secondly, Your Honor, they also made party in first appeal. Although appeal was preferred by some co-defendant, but they are also made party before the first appellate court, as well as Honorable High Court in second appeal, Lordship. But they didn't appeal.
What about notice in those cases?
Yes.
In the appeal and second appeal, where notices served?
Notice served, Lordship. Notice served. And first and foremost, my objection, Lordship, they ought to have filed application under Order 9 or appeal, alternately, which is also held by Honorable Supreme Court. What is the remedy against Order ex-parte decree? Last page, Lordship, paragraph 16, subpara. May I read, Lordship? Last paragraph. Paragraph 16. Two options are there. Order 9, Rule 13 application or prefer appeal. Except these two provisions, Your Honor, the petitioner has no other alternative option against ex-parte decree, whatever the reason it may be. Non-service of summon on wrong representation. And that to be decided by learned trial court, not executing court. Trial court and executing court, Lordship, are totally different. Rule of trial court and rule of executing court is totally different.
Was a case of substituted service where the High Court held that the said substituted service is not in accordance with the procedure because the notice was not hanged in the courthouse or in the last
Yes.
precedence.
Facts are something.
Here is a case where somebody else appeared in place of the
Exactly.
defendant.
Same.
That is the allegation.
Same allegation made by learned friend of my
No,
petitioner.
no, that is their allegation. That is not
Yes.
the case here.
Yes.
No, here nobody appeared.
You are ultimately against remedy against ex-parte injunction, ex-parte judgment. That has been held by Honorable Supreme Court in this case. What is the remedy against order ex-parte decree? Facts and circumstances, definitely very different,
That
Lordship.
is up to him, what remedy he seeks to pursue.
yes.
But
And this kind of petition, especially before executing court, they could have
certainly
filed.
not the you, because this is technically, this is not an expert degree because the
Yes,
correctly or incorrectly, somebody appeared.
Yes.
He is shown to have been heard,
Hard.
and then so
Ultimately-
your remedy might lie by way of a suit for setting aside a degree obtained by fraud, or maybe one of these for setting aside ex parte degree. But that is all that is up to you. But What we are concerned with is what is the role of the executing court in this? Even if it is allowed, even if FSL report comes in your favor, what is the next step for the executing court? Does not have the power to go behind the decree.
Yes, yes, that's right, my lord, but otherwise, it goes against the petitioner, my lord, then I have nothing to say, my lord. But, my lord, what happened? If it goes in my favor, my lord, then something, my lord, can be done.
What can be done? Where's that provision?
Of executing court is very limited, Lord.
No, only thing is this, the executing court is there, my lord.
Okay, you go through order 21 and find out if there is anything that the executive court could have done, then we might entertain your application.
The problem is, Your Honor, decree, executing education case is pending since 2018. It's a long pending case.
Yes, we'll have it next week itself. This is just for apprising the court whether there is any provision under which executing court could proceed, provided
Yes,
favorable report from the FSL had been received. And if any case law in this regard.
yes, yes.
The prayer of learned counsel for petitioner. The matter again on so and so
24, Lordship, if possible.
to enable learned to apprise the court
24, my lord.
regarding certain law points. Give a date. I agree.
Hello.
As per official dated 16/2, Lordship, service upon the respondent number 3 and 4. He accepted, Lordship. And regarding respondent number 5, Lordship, his name will be strike out.
1 and 2 represented, 3 and 4
3 and 4.
received by brother and son.
1 and 2 has appeared already. Name of the respondent number 5 may be strike out.
Third learned counsel for the appellant. Prayer of learned counsel, the name of respondent number 5 be struck off. It appears that is respect of respondent number 3 and respondent number 4 received by Hakim Ali in bracket brother and Mezabur Rahman bracket son respectively. Can be treated as completed. Members of the household, male members of the household.
It may be come for the hearing, Lordship. They come for the hearing, Lordship.
Service is complete, is the matter for hearing.
This is I'm for the appellant and my learned friend is for the respondent, but they have filed an application, Millard. Now they are applicant. And their application is formular for stay of the injunction order or stay of the case. And my submission, Millard, the case is pending for 2018. Though Millard, I am for the appellant. So let the matter be finally disposed of, Millard, in short period, next week, Millard, any date. And my learned friend may be agree, they are agree also, Millard. And in the title sheet, Millard, I own. And title appeal, Millard, they have owned.
IA is for what?
For stay, Millard. And still 3, 4, 5, 8, na? No, no, right.
So for final, you want for final disposal,
My lord. Millard is pending for 2018.
learned counsel for the
Only
appellant
date-
and learned counsel for respondent. There is otherwise ready for hearing, hence list the matter for hearing on. So I say 141 only.
Right.
The matter is at the hearing stage. And in the meantime, in the last one, that is, they have filed a petition for violation of the order of injunction. And so far, our information goes the order, my neighbor has actually constructed a wall, small wall. And they have actually alleged that we have constructed. Actually, that is not correct. So, entire matter may be fixed for final hearing, appeal itself, your lordship.
Appeal is already being fixed for hearing, man. In the meantime, we have filed an application under order
Will you
39 rule
fi-
4. In the last occasion, they are seeking time, my lord, to file an objection. I did not file an objection. Let them file an objection. Let them deny, my lord. They have not constructed, not violated the
Let
Honorable
him
High Court
come
order.
in hearing, for hearing, your lordship.
Says it is already fixed for hearing.
It's already fixed for hearing.
Any date has been fixed.
Sir, on 26 March, I think.
Yes, my lord. Last occasion, date has been fixed along with this miss case, my lord. But they are supposed to file the objection today. They did not file the
In the
objection.
meantime, we will file the objection, your lordship. Well, matter may be fixed for final hearing, your lordship.
Can be fixed, my
And
lord.
they are the appellate.
So if it is fixed on 23rd of March, so what will happen within these few days? It's a question of allegation of construction of a wall.
Allegation construction, my lord, there is specific direction by this honorable court, my lord, not to construct, my lord. Despite that, my lord, they have constructed over this wetland. Let them file an affidavit, they let them deny, my lord.
Now that they can do, but if we dispose of, hear the appeal finally on 23rd itself, was there any point in dealing with this application now for just 1 or 2 weeks left?
My lord, this is a separate issue, my lord, because whether appeal is allowed or dismissed, my lord, it is another thing. But for violation, my lord,
It is not another thing that will have a bearing upon the injunction order also.
this is the violation, my lord. If violation is totally separate, whether they have violated or not, that has to be decided by this court, my lord. Let them file an affidavit, let them file a say that there is no construction.
All right then. Your case is that you have not violated. Somebody else has violated.
Let them file an affidavit on that.
All right, file your affidavit then. Since you had yourself sought time for filing objection.
File the objection then.
Internet counsel for the. Then said that the respondent will file objection against the application in again on
31st. 30 तारीख में लोगों ने मार्च और 30 तारीख को 30th March or 31st March. 31st March.
in the meantime, respondent may file its objection.
Oblige, sir.
No? And violation against an objection.
May please, Bashir. Bashir, the respondent number 1 died and his 4 legal years supposed to be substitute, and I was filed 3 condemnation, delay of 139 days. And there is abatement and there is another petition for substitution. 3 I was filed. 4/7/2026 is condemnation for delay, 139 days. Bashir.
You are appearing for?
I am for the respondent, lordship. And
Which
in
one?
RSA, I am for the appellant, Lordship. IA, Lordship. And
Who died? The appellant.
Respondent number one, Lordship.
Respondent number one.
Lordship, in para 4, page 5, Lordship, in I number 447,
Respondent in the main appeal.
in the RSA, main appeal. Lordship.
RSA. So they are required to be substituted. And substitution you have filed after a delay.
139 days delay. Respondent one was reside outside of Assam, and his most of the legal affairs reside in the outside the Assam. That's why some delay, Lordship.
Yes, so we condone the delay. Third, learned counsel for the applicant. IS 447 of 26. And respondent. IA has been preferred seeking condonation of delay of how many days? 139.
139 days.
1039 in days in filing the petition for substitution of the legal heirs of the deceased respondent number 1 in the connected RSA number 22 of 2012. The applicants herein are the legal heirs of the said respondent number. This is the respondent number 1. Stated that para 6 and 7. Further submitted the delay on the part of the applicants was not intentional. Hence, the same may be condoned. Having regard to the statements supported. What is of the view that the applicants were prevented by sufficient cause from approaching the court within the period. The delay stands condoned. Allowed. Where is the substitution petition? 449.
449 is substituted.
IF 449 had learned counsel for the applicants. Respondent. An application for substitution. The legal heirs of the deceased respondent number 1 filed under order 22 rule 4 CPC. Read with section 151 CPC. As per the applicant, it is stated that paragraph 4 Therefore, the aforesaid legal errors are required to be instituted in place of the decision. The prayer is allowed accordingly. Legal errors are substituted as respondents number 1 ABCD. Corrections to the first title of the RSA. You have to file amended cost title.
There is another real lordship 448, this is abatement.
448 of 26. This is an application under Order 22, Rule 5 CPC for setting aside the abatement of the connected RSA number 22 of 2012. The respondent number 1 expired on 27/6/2025. And due to non-substitution, the legal errors within the period of limitation, the appeal stood abated. However, the respondents had submitted application substitution of the legal errors by way of IA number 449 of 26, which has been allowed. The legal errors of the decision number 1 has been substituted. The abatement is set at the highest. You are for the respondent, they are for the appellant.
Yes.
Then why did you come and get substituted? The appeal had abated, it was their duty. You have done their work.
Master.
Is the appeal is otherwise ready for hearing.
Lordship, since 2000.
Is the connected and RSA for hearing on.
Master.
11. 13. Event to হয়ে নাকি এটা? চল ভালো লাগে। নাই বলে কেন কি? আচ্ছা না। None appears for the appellant, although name of learned counsel is shown in the appellant is in the cause list. This is a matter of the year 2010. Is dismissed for non-prosecution.
Your Lordship, I am appearing on behalf of conducting counsel, Mr. N. Barua. Your Lordship, item number 25 and 26 are connected with item number 17 and 18 for hearing. So this matter may be taken up with item 17 and 18 for hearing, Your Lordship.
Well, otherwise, the two RFAs are fixed for hearing. These are the cross objections filed in those RFAs. They can be taken up together, say 17, 18, 25.
What you want this to be listed together on?
No, my lord may hear them together today itself.
Yes. Seventeen or logo to say 20.
17, 18, 25. The related matters.
The orders can assist to it.
Yes, this can be taken up with 17 and 18 when these are called up.
May it please your Lordship. Lordship, we have filed this IA for condoning the delay of 15 days in filing this MSC appeal. Service is complete in this regard, Lordship. Respondent number 1, we have taken steps through Dusty, and affidavit has also been filed. And respondent number 2 and 3 were struck off, Lordship, as per order dated 13/2/26.
There is no office note whether anybody has entered appearance.
One has entered appearance, Lordship, respect of respondent number 1.
No, but there was a direction from the court to the registry to put up office note. Not there. But learned counsel for the applicant. Hears that trustee service has been effected upon the respondent number 1. By order dated 13/2/26, registry was directed to put up to date office note as whether any counsel entered appearance on behalf of the respondent number 1 by filing wakalatnama. Such office note on record. Registry to put up office note is above regard. The next date fixed. Again on next week.
27th of life.
My lord, may I crave your lordship in- I am appearing in item number 13, my lord, which is connected to the supplementary item, my lord, also before your lordships. I was a little late, my lord. I was in another court. I thought it would be taken up a little later, but lordship has been pleased to dismiss it. So can you take up the matter, my lord, or argue on it, my lord?
Item
13, my lord.
all right, 13. This is connected to
Their item number, my lord, yes. Which interlocutory item number, my lord? Human Assil supplementary list of 24, my lord. In fact, my lord, I wanted to, my lord, have some time from your lordships for about 7 days because I had misplaced the earlier fine in number 14 also. And these also, my lord, I will have to, my lord, make the entire file, my lord, again by taking certified copies from the LCRs, my lord. So lordship will be, my lord, kind to give me, my lord, at least 7 days time, my lord. I'll take the copies and then I'll prepare
right.
myself properly, my lord.
Card Mr. G. Chaudhary, learned counsel for the appellant. It is a very old case. But trace out the records. Praised for 7 days time to reconstruct the file by obtaining certified copies. Prayer is allowed, list the matter again on
You oblige, my lord. And in respect to item number 14 also, my lord, similar orders will be possible.
14.
14, my lord.
All
In item number 14, I am appearing for the respondents. But I don't have the file, I don't have anything, my lord, everything will have to be collected.
right, list the matter before another bench without me. Has been submitted by Mr. G. Chaudhary, learned counsel for since this is an old pending matter, very old pending matter. Trace out the file. Just to reconstruct the same. Prayer has been made for granting 7 days time for this. Is the matter after
10th
bench?
10th of March. Will be permitted just to go through the records, my lord, so that my lord work out whatever is required. And be prepared.
Next is the lordship. This appeal is under section 30 of the Workmen's Compensation Act, my lord. The only issue involved in the present appeal is whether interest could have been awarded from the date of accident or from the date of, from the due date, when the injury in question is a non-scheduled injury under section 41C2 of the Employers' Compensation Act, my lord. Here, may I read the judgment, my lord?
Yes.
The case arose in a claim petition under Workmen's Compensation Act 1923 by the claimant petitioner for an award on account of personal injuries caused to Muhammad Ahid Ali in course of his employment. The case in brief is that Muhammad Ahid Ali was employed as labor under the opposite party number 1, the owner of the vehicle number so-and-so on 10/4/2002, while the vehicle proceeded from Dominic Quarry towards Borpeta Road. The vehicle met with an accident at Katachar due to sudden failure of main spring. As a result, the petitioner sustained grievous injuries. The petitioner first treated at Borpeta Road Public Health Center, and after that he was referred to Borpeta Civil Hospital for better treatment, but he is not cured and remained disabled since the date of accident. A case was registered by GDA number 314 dated 10/4/2002 under Borpeta Road Police Station. He earned rupees 3,000 per month as salary and his age was 30 years at the relevant time of accident. The employer had knowledge of accident, but he did not get any compensation from the opposite parties. Further, the petitioner stated that vehicle was insured with OP number 2 and 3 National Insurance Company, policy number so-and-so, and was valid at the relevant period. And the petitioner further stated that he submitted all the relevant documents to substantiate his claim. Due to unemployment, he is facing acute financial hardship with family and demanded due compensation as per rule. The OP number 1, the owner of the vehicle, in his written statement admitted that the petitioner was his labor who sustained grievous injuries in the accident on 10/4/2002, and further admitted that the petitioner earned rupees 3,000 per month as salary, and the said vehicle was insured duly with OP number 2 and 3 National Insurance Company Limited by policy number so-and-so, and it was valid at the relevant period. So the OP number 2 and 3 liable to pay any compensation and prayed to exempt him from any liability for the end of justice. The opposite party number 2 and 3 insurance company in their written statement denied responsibility suggestively and mainly on the ground that the claim is not at all maintainable in the present form. There is no cause of action, no notice served to the opposite parties under section 10 of the Workmen's Compensation Act 1923 and denied about accident, employment, salary, injuries, age, and stated that the claimant is put to proof thereof. Heard written argument from the insurance company limited and oral argument from the claimant side put forwarded for and against by the learned counsel, and on pleading the following issues have been framed. Is there any cause of action for the claim petition? Whether the claim petition is maintainable in its present form, whether the OPs are liable to pay compensation as claimed by the claimant petitioner. If yes, what relief is the claimant petitioner entitled to? The claimant petitioner is labor of the said vehicle and has been examined by the learned advocate of the case, adduced documentary evidence pertaining to his claims such
All
as
right, but the substantial question is only with regard to the time from which the interest
time from which
date of accident. So what is the law on that point?
Miller, in this case, under employees come, there are two types of injuries, Miller. One is scheduled injuries and non-scheduled injuries. Scheduled injuries are stated in the act itself, Miller, and against that injuries, the loss of earning capacity was mentioned. And in case of scheduled injuries, Miller, interest has to be calculated from the date of accident, Miller. But in case of non-scheduled injuries, interest has to be calculated when it fails due. That means when the claim is adjudicated, Miller, and that is not from the date of accident.
Section, where is that provided?
Section, your lordship may kindly.
Workmen's Compensation Act.
Section 4A1 of Employees Compensation Act.
Employees or workmen?
Employees, before it Workmen's Compensation, now it is Employees Compensation Act 1923. To নাই এটা
Okay, you read.
For a compensation to be paid when due and penalty is separate and penalty for default. Compensation under section 4 shall be paid as soon as it falls due. Now, in cases where the employer does not accept the liability for compensation to the extent claim, in the instant case, the employer does not extend his liability. Therefore, the claim case registered, my lord. He shall be bound to make provisional payment based on the extent of liability which he accepts, and such as payment shall be deposited with the commissioner or made to the, as the case may be, without prejudice to the right of the employee to make any further claim. Subclause 3, where any employer is in default in paying the compensation due under that within 1 month from the date it failed due, the commissioner shall impose penalty, my lord. Now, the question when it fails due, my lord, the Honorable Supreme Court in a case paragraph number 9, my lord. Para 9, my lord. Interest is payable under section 4A3 if there is default in paying the compensation due under this act within 1 month from the date it failed due. The question of liability under section 4A was dealt with by this court in Magar Singh versus Jaswant Singh by amending Act of 30 of 1995. Section 4A of the act was amended inter alia, fixing the minimum rate of interest to be simple interest at the rate of 12%. In the instant case, the accident took place after the amendment, and therefore the rate of 12% is fixed by the High Court cannot be faulted. But the period as fixed by it is wrong. The starting point is on completion of 1 month from the date on which it fell due. Obviously, it cannot be from the date of accident. Since no indication is there as to when it becomes due, it has to be taken to be date of adjudication of the claim. This appears to be so because section 4A1 prescribes that compensation under section 4 shall be paid as soon as it falls due. The compensation becomes due on the basis of adjudication of the claim made. The adjudication under section 4 in some cases involves the assessment of loss of earning capacity by a qualified medical practitioner. Unless adjudication is done, question of compensation becoming due does not arise. The position becomes clear on a reading of section 2 of section 4A. It provides that provisional payment to the extent of admitted liability has to be made when employer does not accept the liability for compensation to the extent claim. The crucial expression it falls due significantly legislates not use the expression from the date of accident. Unless there is an adjudication, the question of an amount falling due does not arise. Here the adjudication, adjudication date is the date of judgment, Miller. Therefore, it fails due after 1 month from the date of judgment, Miller.
Yes, respondent.
My lord, cases pending since 2010, my lords. My lord, total awarding amount is my lord, 1,12,309, and interest amount is 54,245 rupees from the date of accident, my lord. The date of accident is 10/4/2022. They have deposited the amount on 22/1/2008, my lord, and date of judgment on 22/8/2007. After 4 months, they have paid the principal amount. but not pay the interest amount. My lord, in the judgment, my lord, judgment of the judgment, my lord, page 5, my lord. There is mentioned so many so many cases of Supreme Court as well as High Court, my lord. I have read, my lord. Judgment page number 5, last paragraph, my lord.
Judgment,
Yes, my lord.
page number 5.
Number 5, my lord.
Yes.
Last paragraph. The above mentioned interested shall have to pay by the insurance company or per verdict of the Honorable Supreme Court of the Indian in situation in 1998 clause 1 TA C 215 SC. Respect of case.
You want to quote the judgments given by the court below?
Court below, yes, ma'am.
What are those judgments? Tell us. What does the judgment say?
My lord, tribunal judgment, my lord. Now, in their appeal petition, my lord, their appeal petition, my lord, is annexed the judgment, my lord. একটু বোঝানো হয় এখানে না একদম বোঝানো আপনি যদি appeal petition.
Which portion?
Page number?
But
But these citations have been annexed to the appeal memo.
no, my lord.
Then
And there is a discussion in the tribunal judgment.
Tribunal discussion, tribunal judgment.
this discussion regarding the date from which the interest would become due.
Yes.
Where is that?
Let's kindly peruse the appeal memo. There they have annexed the judgment of the court below, my lord.
That is already before us. That is what we are reading. What do
Yes,
you
my
think
lord.
we have been reading all this time? Don't make useless submissions. Have you read the judgment or not?
They have served the copy.
You don't
And
even
this
have a copy.
petition- This petition, there is no mention in the page number, my lord. That is why we have the problem, my lord.
Beth Prakash Garg, my lord, Beth Prakash Garg is on different point, my lord. In Beth Prakash Garg, there is a discussion whether insurance company would be liable to pay penalty, my lord. In that case, the Honorable Supreme Court has held that insurance company has to pay the interest, but not the penalty. Where there is no discussion when the interest becomes due, my lord.
Page number-
Which page of the judgment it is discussed?
Page number 5, in award portion, my lord, and the last.
No, those are just the citations. Where is the discussion?
That is Supreme Court had given, but the compensation along with interest to be payable by the insurer. I am not denying that I am not liable to pay interest. I am from which date I have to pay interest? That is my substantial question.
Yes. Take down. Had learned counsel for the appellant and learned respondents. This appeal is directed against the award. Appeal under section 30 of the WC Act, okay. 1923, directed against the first cause title, okay. Appeal memo. The present respondent as payment had preferred, had instituted a case being case number WC 5 of 2004. Commissioner of Workmen's Comp. In compensation on account of personal injuries. Employment. Of his employment. Page 6, first para. Parties being the owner of the vehicle. The insurance company stated written statements. Same. The learned Commissioner of Workmen's Compensation was the impugned award. Awarding a compensation of rupees 12,309 with interest at the rate of 9% per annum on the awarded amount from the date of the accident, which occurred on 10/04/2002, into rupees 4,245. Amount of imputed as rupees 554. Being aggrieved, the present insurance company, the question of the substantial question of law formulated at the time of admission of the appeal is as follows: whether the learned commissioner was justified in fastening the liability upon the appellant company to pay interest the awarded amount from the date of the accident. It at page 2. Yes, learned counsel for the appellant insurance company has submitted that as per section 4A, schedule injury 4A.
Mention separate. Latter part of the book.
Okay, we need not go into that part since it is an admitted position that this is not a schedule injury. All right. That means that undisputedly the injury sustained by the payment respondent is a non-scheduled injury. In this regard, learned counsel has referred to section 4A of the Employees Compensation Act. Which reads as follows, section 4A. Okay. Learned petitioner has placed before the court the decision of the Honorable Apex Court in National Insurance Company Limited versus Mubashir Ahmed and another, wherein it has been held as follows, paragraph 9. The learned tribunal, learned commissioner of work compensation had referred to certain decisions of the Honorable Apex Court in the MPM judgment. But none of the said decisions are on the point as to the date from which the compensation would become. Interest on compensation would become due. Having regard to the above, the substantial question of law formulated above is answered by holding that the employer stroke insurer is not liable to pay just on the compensation from the date of the accident. But rather the starting point is on completion of 1 month from the date of the date on which the award was made. Having regard to the decision of the apex court. In some Abbas Syed National Insurance Company versus Musabir Ahmed Supra. The appellant is therefore directed to calculate the interest payable accordingly and you have made a statutory deposit. No deposit is there. And no amount has been paid till date.
Yes, the awarded amount has already been paid.
Awarded amount. So it will be what, refund?
No, only the interest, first the insurance company has not
What
deposited.
part has been paid? Main
They have-
amount, main compensation.
So they have paid the 1,12,309. They have deposited.
It is
Awarded amount was
They
deposited.
have deposited. Only disputed amount.
interest part was not deposited. Since the awarded amount minus the interest part has already been deposited, the insurance company is now directed to recalculate the interest in the light of the above and pay the same to the respondent claimant within a period of 3 months. In a period of 3 months from today. The appeal stands disposed of accordingly.
Pleasure.
But this matter has been listed after 2012 first time. Name. Do you have any information about the other side?
Lordship, in fact, it is listed after
None appears for the appellant. Respondents are represented by learned counsel. It appears that this matter has been listed for the first time after 21/3/2012. However, the name of learned counsel had appeared for the appellant, that is Mr. B.C. Das, Mr. S.B. Prasad, and Mr. D. Day have been shown in the cause list. Hence, list the matter again on next Thursday. Which are we required to take up first?
My lord, may take up this title suit, RFA 116 of 17 arising out of TS 86 of 2010.
Item 17.
This is Dr. Kishore Das, yes.
Item 17.
Item 17. Item 7. The appellants versus Dr. Kishore Kumar Das. May I begin, ma'am? The appellants are the defendants number 1 and 2. The title suit 86/2010. Suit was filed for various reliefs, which I may pray with your lordship that I am permitted to read the particular reliefs. This is at page 35 of the memo. Page 29 of the suit. Read the reliefs, my lord. King, decree of declaration in favor of the plaintiff and against the defendants. Defendants are bound by the registered deed of agreement bearing number 8705 of 2007, dated 6 July 2007, executed by and between the plaintiff and defendant number 1. Again, a decree of declaration in favor of the plaintiff against the defendants for specific purpose of the registered deed of agreement bearing number 87057, dated 6 July 2007, in respect to the area more specifically described in Schedule 8 of the plain, thereby directing the defendant numbers 1 and 2 to obtain the permission from the GMDA, Gauhati Metropolitan Authority, for conversion of the Schedule A area into semi-finished area and thereafter execute a registered deed of sale in favor of the plaintiff in respect to the Schedule A area as per the registered deed of agreement bearing 870507, dated 6 July 2007, in time frame specified by this honorable court, failing which the deed of sale be executed and registered according to provisions of the so-and-so of the Code of Civil Procedure. And third prayer is for decree of permanent injunction, restraining them from defendants from allotting the Schedule A area mentioned in the plain to any other persons. And alternatively, they prayed for decree of recovery of 40,30,124 at page 37. Defendants on account of recovery of the principal amount along with interest, as well as for special damages as stated in paragraphs 28, 29, 30 of the instant plain. And thereafter praying for decree for general damages, costs and other reliefs. Now, my lord, we come to page 38. This is the Schedule A. What exactly do they require? This is the ground floor space, page 38, as my lord, that page. Ground floor space of 1000 square feet under flat number 101A1 of the apartment known as Megmallar Hillview, situated at Ganeshguri, Jotia, Gauhati, standing over a plot of land measuring 1 bigha so-and-so lectures, covered by Dag number so-and-so of KP Pata number so-and-so, village Jotia, Mocha Bet so-and-so, bounded by the boundaries. So, my lord, the issue herein is that they entered into registered deed of agreement. I am the builder. Registered deed of agreement for purchasing a particular 1000 square feet of ground floor space in a particular apartment complex, which is known as the Megmallar Hillview. They, after that, the case built up by the plaintiff herein because there are two suits presently going on. Both suits proceeded independently. No common judgment decrees proceeded, separate judgment decree in order, separate appeals and separate objections have been filed in both these proceedings. So if I take this suit first, filed by the husband, that's two people, husband and wife have both filed independent suits. Husband has filed for 1,000 square feet of ground floor space. His setup contention is that his wife had purchased the first floor space around particular 1,200 square feet, 1,300 square feet, and at a particular price consideration. Thereafter, as his wife had purchased the flat, he purchased a ground floor space, intending thereby to create a contiguous area, which they would then use as a doctor's clinic. The entire space, using the waiting room, reception, chambers, clinic, both are doctors. So that is the case they are building up. Now, when that ground floor space permission from the GMD did not come through for conversion, because my lord is aware that that ground floor space has to be kept only for parking. That permission did not come through. They tried to compel the builders to obtain the permission by some way or the other. Builders, the appellants saying, they have stated that this is not permissible in law. We can give you the space. You build whatever you have to if you can get the permission. But on top of that, making a doctor's chamber, a clinic, a commercial establishment, on top of that, utilizing the ground floor space as a built up area, which is again not permissible in law. Therefore, this agreement became impossible to perform. Now, the next question would be, if that agreement becomes impossible to perform, either the plaintiff elects to take that space, that 1,000 square feet as his basis, or to get the refund of the money that has already been paid for, with whatever interest. Now, for that, since this particular relief or the particular suit is a feature of the act itself, and it is dependent wholly on the terms of the contract they are agreed into, I implore my lord to, even though there is a related transactions, related cause of action between both what as the present plaintiff has sought to buy, the reason why he's bought the ground floor space, as well as the reason why his wife has bought the ground floor space. For the purposes of law, we have to concentrate only on the agreement that deed 8705, whether that is capable of enforcement. If that is not capable of enforcement, what is the consequential relief that can be granted only in respect of that agreement. My first submission is that all other reliefs which they are praying for, which may have a bearing on what their intentions were at the time of purchasing both husband and wife, that cannot be considered or looked into at the time of deciding what is exactly the relief to be granted from that registered agreement, that particular agreement. So, my lord, I'll take my lord to that agreement. That is the main agreement at page 67. That deed is at page 67. Everything flows out therefrom. Starts at page 67. Yes. This deed of agreement made on 6 July 2007 on this between Mrs. Meghmala Estates and Services Private Limited, represented by the Managing Director so-and-so, number 2, all first party and the defendant herein. There is a second party. Now, my lord may come to page 69. The second paragraph. Whereas the second party, the respondent in the appeal, plaintiff, applied to the first party for allotment of 1,000 square feet in the ground floor in the complex known as Meghmala Hillview, situated at Ganeshguri, Zotia, Gauhati. And whereas the second party agreed to purchase ownership basis at so-and-so, having 1,000 square feet on the ground floor in the complex described above for a consideration of 9,30,000 against cost of floor, roof, proportionate share of the land and construction charges, including raw materials, which will be paid as described in Schedule D. Now, my lord, again, here this point is crucial because the plaintiff keeps a recurring theme that he intended to construct a doctor's clinic. Therefore, once that permission fell through and that built-up area could not be constructed, there was a breach of contract. The allegation is there was a breach of contract or a breach of promise on part of the developer or the builder. My first argument is that the promise has to be read from the agreement, and the agreement says 1,000 square feet of ground floor space. Again, next page, man. I'll read only specified paragraphs in the agreement, not the entire agreement. Page 70. Paragraph 1. In terms and conditions of the allotment of an apartment or Megmalla, the intending allottees applied for allotment of an apartment with full knowledge and subject to all the laws, notifications, and rules applicable to this area in general and group housing project in particular, which have been explained by the company and understood by him or them. Paragraph 3. Intending allottee has seen and accepted that plan design specifications set out in brochure, agrees the company may make such variations, alterations, and modifications therein as it may sole discretion deem fit and proper, or as may be done by competent authority. Intending allottees hereby gives his or her consent to such variations, additions, and modifications. Paragraph 4. The company shall have the right to effect suitable necessary alterations in the layout plan of the buildings, if and when found necessary, which alterations may involve all of the following changes, namely change in positions of the apartment, change in the number of the apartment, or change in the dimension or change in its area. To implement any or all of the above changes, supplementary agreement, if necessary, will be executed. If there is any change to be made, supplementary agreement will be executed. Any decrease in area, rate, other changes will be applicable to change area at the same rate at which the apartment was booked. If for any reason the company is not in a position to allot the property applied for, the company shall refund the amount deposit with simple interest at the rate of 10% per annum. This is an undertaking on behalf of the applicants, the company itself. We'll refund if we cannot allot the property applied for. My lord, may come to paragraph, page 72, paragraph 13. This paragraph only relates to payment of the stamp duty, registration charges, incidental legal expenses for registration of sale deed, and gives them a proportionate share of the land according to the built-up area. So they will have to pay the other incidental and other expenses. Page 73, paragraph 19. Which is important. The intending allottees agrees that if a result of any legislation, order, or rule, the company after allotment is unable to deliver possession to the intending allottee, the only responsibility and liability of the company will be to pay to the intending allottees the amount attributable to the said apartment that may have been received by the company at the time without any interest or compensation of whatsoever nature, and in the manner as may be decided by the company, same as aforesaid. Title party shall have any right or claim against any order in relation to this agreement. So therefore, if in a result of any legislation or law, basically operation of law, the allotment could not be made, then again, it has to be refunded back. And the rate of interest is 10% per annum. This is the agreement. And the schedule, the page 74. The schedule A is the entire plot of land, description of the plot of land. Schedule B is the apartment complex. Schedule C is important. Allotment number 1,000 square feet open space on the ground floor under flat number 101. Page 74.
Yes.
Schedule A is the land description. Schedule B is the apartment complex. Schedule C is the particular allotment area in question, 1,000 square feet of open space on the ground floor under flat number 101/A1. The reason being flat 101/A1 being specified is that it is below the flat of the wife. So they wanted a contiguous area. Again, that also has some bearing on that. And schedule D is the payment schedule. Now, my lord, from a bare reading thereof, the prayer which is made, alternative prayer, which is made for payment of 40 lakhs, that is not maintainable.
How does this figure of 40 lakhs come?
Their contention is that, in brief, I would describe that together, both the husband and the wife, they have paid around 33 lakhs. Where they had to pay, and they had to pay 3 lakhs more, as per their contention, that they had already paid 33 lakhs for the entire structure, the first floor flat, ground floor space. And because the permission was not granted, they had exercised one option of having a contiguous another flat in the first floor. But the plans and the designs do not permit of a contiguous space. There is a staircase between the flats in the first floor. This we had explained to them, that it cannot be contiguous. You may have it on the same floor, but it may not be contiguous. However, they insisted on the contiguous part, which is not present in any of the agreements they are seeking to enforce. So when they did not get the contiguous flat, they said that now our plans fail to set up the doctor's chamber. Therefore, the 33 lakhs, whatever we have already paid, and again, plus interest, delay on the delivery of the
That
flat.
first floor apartment also, they are not, they do not want to take anymore.
They are saying it has no use to them, utility to them as such. It was never meant for residential use. It was only for doctor's clinic. As of now, the first floor apartment is also vacant. So that is occupied by no one. The ground floor space is also vacant, occupied by no one. Other rooms in the apartment complex are occupied. The question is herein, when they say ask for relief of 40 lakhs, alternative relief, if a relief, they have paid 12. As per their own admission, they have paid 12 lakhs. So the consideration was no 9 lakh 30. They have stated to have paid 12 lakhs.
In respect of both
I'm talking only of one, the ground floor space. That is, the husband says, I have paid 12 lakhs for my amount, and my wife has paid the remainder, total coming out to around 33 lakhs, 30 lakhs. So 30 lakhs, 30 lakhs. This is 30 lakhs or 33. So 3 lakhs are left unpaid as per their own statement. My second contention is that these are two different suits, two different proceedings, appeals. You cannot club the payments made by one plaintiff with the payments made by another plaintiff. More so when the Honorable Court below had held that these two are separate.
So the husband and wife both have instituted different suits in respect of the two properties.
And the wife is not a party in one of the suit, husband is not a party in the other suit. So suit was held to be maintainable. There is no non-joinder of parties or necessary parties. So in that event, when the husband or the plaintiff as a plaintiff seeks to bring in the factum of payment made by his wife as a separate contractee, therefore, automatically the corollary question will be that wife or that person becomes a necessary party in that suit. In the absence thereof, the question of proving of whether
what has been decreed?
Has been decreed that specific performance has not been 12 lakhs, whatever the husband has paid, to be paid back with interest.
What is the difficulty with that? They did not allow 40 lakhs.
They did not pay 40 lakhs. They did not allow the 40 lakhs. My only grounds was that my only limited grounds was, if I may read the grounds, that they relied on certain, Honorable Trial Court relied on certain exhibits, which were payments made by the wife in the suit without having the wife as a party, without proving those exhibits. It was as if the husband was literally taking over the charge of the proceedings on behalf of his wife. There is a separate difficulty because in the suit filed by the wife, she never deposed. Her husband deposed. There is admitted that she.
This item relates to the husband's
suit.
That 1,000 square feet.
1,000 square feet. In the other suit, the wife filed the suit, but she never deposed in evidence. No examination, no evidence deposed by her as a plaintiff.
Now, this 12 lakh was awarded on the basis of what?
This 12 lakh was awarded on the basis of payments made by the husband.
Which was admitted by you?
Not admitted in part. We have stated that the admission that I made is that I have made received a payment of 5 lakh amount I have received from the husband, plus another amount received from the wife, not 12 lakhs in total. That is why I have been aggrieved by the appeal. That's because 33 lakhs which they have paid, an amount, roughly half of that they have paid for modifications in the two spaces to make that area contiguous. They have torn down walls, they have made modifications, they have utilized my engineers to make modifications to make a particular, not a residential flat, but a doctor's clinic. Those internal modifications they have paid. They have paid 30 lakhs, for most of which comes from the internal modifications. So my contention is that when you have contracted to pay a particular sum for a flat, as the agreement says, it covers that sum, covers the construction cost, materials cost, labor's cost, not for additional modifications which I may want. I may want a false ceiling. If the plan does not envisage a false ceiling, it comes out of my pocket. It cannot be deemed to say that I have paid the builder. And the builder, therefore, has to deliver me a flat with a false ceiling. I'm just giving an example, my lord, that certain modifications, extra fittings, furnishings were made in the interior, not the exterior, interior of that flat, for which they paid separately. But they are seeking to club that amount with the consideration, thereby raising the argument that I have paid more than that was agreed for. If the agreement is 9,30,000 consideration, if there is an escalation, again, the agreement envisages that a supplementary agreement would be executed that the flat price has increased, therefore I have to pay an X amount more. They have paid something extra. They obtain receipts that paid a lump sum paid of 30 lakhs. They have a receipt. One receipt they have admitted paid by one of employee of the company received so and so 30 lakhs. There is no mention in that receipt as to on what account that 30 lakhs was paid, because it is not the consideration amount. It is far more than the consideration amount. And there are letters, I'll read, Your Lordship, there are letters, exchange of correspondence, which show that I have all along asked them, take possession of the flat, take possession of the ground floor space, or take your money back. The first dispute arose whether it is the 12 lakhs which they've actually paid towards the consideration. And if they have paid for consideration more than what was agreed to, where is the supplementary agreement showing escalation in the rate or the floor escalation in the price of the flat? It is all on basis of letters, correspondence. One person says, I have paid 20 lakhs, I have paid 15 lakhs. Why don't you hand me the flat? That cannot be the proof that sale consideration was modified. More so when I have raised a specific plea that there are alterations done, and this has come particularly from a particular letter, which I will.
So the agreed amount was 9,30,000.
9,30,000.
Out of that, you admit 5 lakh has been paid.
Has been paid.
Rest, what he claims is on account of improvements or modifications or whatever.
Improvement or modifications. I will just, I'll just verify the amount. I've been saying 5 lakhs. I think it is a bit more, just 6 lakh. I'll just verify. But admittedly, it is not 12 lakhs is not the sale consideration that is paid. It includes components which they have paid to my engineers and designs unilaterally on their account to modify the interior of the flat or the space. So there is again, both sets, there are certain transactions which have merged into both because they intended to set up both spaces as one unit, as a doctor's clinic. So they have made payments unilaterally and mixed up the entire issue. Therefore, I had raised the preliminary objection that the wife had to be a party and the husband had to be a party in the other suit because they are making pleadings and averments which require the presence and evidence to be taken of both the spouses together in one suit. That was negated. I'm not on that. But once it is negated and saying that this is a standalone suit, it is not open for them to bring in transactions, receipts, bills from another proceeding and show it as proof. Merely exhibiting without proving by the author or the person who has received the payment or person who has made the payment, in this case the wife, would not amount to proof of the payment. There are certain, they have exhibited a series of challans. I have exhibits numbers, I have given the exhibits in my ground as well. These are certain exhibits, these reflect payment made by a 2 lakh paid by the wife, 1 lakh paid by the wife. These are all installment payments. First of all, if there's a challan there, the person who has made the payment has to prove that I have indeed made that payment. Or the person, if the husband is acting as a power of attorney holder, he's saying that I'm doing all these things on behalf of his wife, he must show a document that I've been authorized. All along, I have been making the purchases, making the payments on behalf of my wife. My wife is not bothered with the details. I am the person competent to depose. There is no averment, there is no document to show that the husband is the one who is doing all these transactions. Whereas he has deposed in his own suit, he has deposed on behalf of his wife as the plaintiff in the other suit. And now he is basically proving payments made by his wife merely on his say-so. Now, on mere averment is there that I am in knowledge of the particular transactions, of all the transactions being made. He may be, but a payment is being made by a separate contracting party. Mere ipso facto being his wife would not give him the authority in law to depose as to whether that payment was actually made on what context that payment was made, whether it was made towards the sale consideration or towards any other extra payment. That is the difficulty which we are facing in these two suits, because appeals are being heard together, but the suits were disposed by different judgments and orders. And there is inter-reliance on documents. Even in the other suit, they are relying on other documents. For example, if my lord picks up a particular letter, it will make certain things clearer. Page 106. Exhibit 28, page 106. This is their letter. I'll read it in its entirety, my lord. This has some bearing on the entire dispute. To Mr. Amseka, Managing Director, Megmala Estates and Services Private Limited, from Dr. K.K. Das, so and so, dated 19 February 2009. This is before the suit. Suit was of 2010. Sir, in reference to your letter dated 10 February 2009, I would like to inform you of the following facts. I and my wife, Dr. M.D. Mazumdar, Senior Consultant Gynecologist, have decided to purchase a ground floor space of 1,000 square feet for a doctor's chamber cum clinic and a 3-bedroom flat on the first floor for residents at Megmallar Hillview Apartments at Jatia Ganeshguri. So here is this version is different. The 1,000 square feet ground floor space is for the doctor's clinic, and the upper 3-bedroom flat on the first floor is a residence. That changes, the version changes from the pleadings. I'll come to that. At that time, the project was in the initial stage and NOC for construction of the ground floor space had not yet been received by the company. After discussing with other directors of the company, he informed us of 20 June 2026. This he would be is not clear, but he probably refers to the defendant number 3, one of the other directors of the company who was not a director at that point of time, and who had admitted that he had never discussed this with the other directors. So this again is important. He would refer most probably to defendant number 3 there. So, if the NOC for the ground floor space is not possible, then the company will provide a 2-bedroom flat on the first floor contiguous with the 3-bedroom flat allotted to my wife. Now this is again nowhere, no written assurance given anywhere, no agreement to such effect. The price was fixed at 33 lakhs. Again, he is clubbing with the space, with the flat of his wife. The 33 lakhs does not show up on any consideration. 9 lakh 30 plus another 12 lakh of the wife. So where does this 33 lakhs come from? It is not fixed. It may have been paid, but for what reason was paid, it cannot be said to be a fixed price of 33 lakhs. Provided we made an advance payment. We readily agreed and paid 4 lakhs on 26/6/06, around 6 months before the project started. Another 4 lakhs were paid on 12 February 2007. We had taken a loan of 9 lakhs from SBI PBB Ganeshguri branch, and the bank paid the amount directly to Megmallar and so in 2 installments. So again, this loan has been clubbed. He has taken a separate loan, his wife has taken a separate loan, but they are again clubbing it. So we received a final call letter on 29/5/2008 informing us about the balance payment of 11 lakhs 1,025 only, including all extra bills for the project and a single car parking space. After receiving the final call letter, we paid rupees 2 lakhs on so and 3 lakhs on 5/9/2008. So on receiving, even if I take the admission, their statements at face value, they received the balance payment call of 11 lakhs 1,025. And after that, they have paid 5 lakhs. On one occasion, 2 lakhs on 9 August 2008 and 3 lakhs on 5 September 2008. So therefore, till now, there is no mention of any dispute as such per se on the consideration. Whatever be the fixed amount, the demand was raised for 11 lakhs, they have paid for 5 lakhs. Let us take it at face value. I'll be proceeding only on face value right now. During the construction, a lot of changes had been made to make the ground floor space and the 3-bedroom flat on the first floor to become a single contiguous unit. This is the contradiction. The 3-bedroom flat is a residential space. So they have again made a lot of changes to make this ground floor space and a contiguous unit. The Lord will appreciate to make two different floors units contiguous, how much renovation and reconstruction is required. Literally, they have to break particular portions of the floor as well as make alterations in the internal plan. This was done under the supervision of site engineers Mirgen Chaudhary and Biswajit after taking the consent from me and Mr. Utpal Das. So again, there is no mention herein of any consent being taken from the builder or the assurance being given by the appellant's builder herein that we will make this a contiguous space. That you leave this amount to us for the extra payment that you have given to us, we will make this a contiguous space. Rather, the tenor of this letter suggests they have on their own accord proceeded to make the 2 units a contiguous space. Quite possible, quite natural. They're husband and wife, they can do whatever they want. They have purchased the 2 units. But to later foist the responsibility upon the builder saying that you have agreed to give us a contiguous space, that is stretching it a bit too far in my submission. Next, I met you for the first time on 23 June 2008. During the discussion, you informed me that the front of the GF ground floor space will not be provided. Again, this is a bone of contention that in order to have a clinic, they require 400 square feet of frontage. That will be apparent from when I go to the pleadings. Frontage is not permissible in a residential building. In a commercial space, we have frontage. In a residential building, apartment complex, there is no question of frontage. And the agreement does not mention any frontage, 400 square feet, 10 square feet, no frontage. Here they are saying they're taking it as a fait accompli, that somebody has already agreed to deliver a piece of frontage, which is never on the record. Then I told you that it will not be possible for me to open a clinic without a frontage. So even as on 2008, he knows there is no agreement for a frontage. He knows that it is not possible to open a clinic without a frontage. Where is the question of leading him on or duping him or cheating him with a false premise of helping him create a clinic? I asked for the second option as per commitment to provide me a 2-bedroom flat contiguous with the 3-bedroom flat on the first floor allotted to my wife. But you informed me that the concerned 2-bedroom flat had already been sold off. Let me know your decision in the first week of July. I met you again on 9 August 2008 for further discussion. You then agreed to provide me the ground floor space with frontage if you can arrange the NOC. Again, a conditional. If the state government allows or a GMDA allows me the frontage, then as a builder, what objection would I have to providing him the frontage? But again, contingent to the place that there must be statutory approval for the same. There is no assurance. I cannot assure that I will go around the statute and provide him the relief. I received a provisional plan of the ground floor space of around 1,125 square feet with frontage on so-and-so. This plan was brought to me by site engineer Mirgen Chaudhary and Biswajit. I totally agreed with this plan. Again, he refers to the site engineers. They are providing him basic plans as per his wishes and desires, but that has to be approved. I met you again on 23 September 2008 at 7 p.m. for fixation of the price of the extra space. Again, there is a question of extra space. You inform me that the valuation of the land in front of the GFS will be done shortly. A slightly changed new plan of the GFS ground floor space than the earlier one was given to me on 3/10/2008. This was to be the final plan if you can arrange the NOC. According to this plan, total area of the ground floor space was around 1,010 square feet and the land in front of the ground floor space was around 463 square feet. You fixed the price of the land at around 6,29,000, but I offered rupees 5 lakh. Later on, I agreed to pay rupees 5,50,000. These are oral letters. How can letters really take the substitute the agreement which has already been signed, 80705? And if the 8705 agreement no longer exists, then what are they exactly trying to specifically enforce by way of the suit? They're all letters. I sent my PS, Mr. Kamal Singh, to your office so-and-so to take an appointment for me on my behalf. At the time, he was given 3 documents from my office where written that in spite of your best efforts, we had not been able to arrange the NOC for a GFS. So I met you on 8/1/2009, requested you to provide me the 2-bedroom flat at the first floor adjacent to the 3-bedroom flat that has been allotted to my wife at a price of 33 lakhs as committed earlier. Unfortunately, we had a heated discussion regarding this matter and result no final decision could be taken. In the evening of the same day, I received a receipt for the rupees 30 lakhs that we had already paid for the project. So there is a receipt there, not signed by me, receipt of 30 lakhs. Lump sum payment of 30 lakhs. No mention of what consideration, which flat. On 10 February 2009, I received a letter from you through speed post asking for my reply before 28 February 2009 what option I would take regarding the ground floor space. I immediately tried to contact the Megmala person who had supervised our units and had done the paperwork. Talukdar did the paperwork and Mirgen Chaudhary and Biswajit supervised the units. But unfortunately, I could not contact them as they were no longer in our organization except Mirgen Chaudhary. So I contacted Mirgen Chaudhary and I requested him to inform you about my proposal as mentioned below regarding the ground floor space. I also sent an SMS to you on 13/2/2009 about my proposal. My proposal is that if this is not possible to provide me the ground floor space because of not getting permission from GMD, then I'll be satisfied with the 2-bedroom flat, contiguous or even adjacent. Again, a change. Now there is adjacent flat will do also. First, he has to stick to one. What exactly does he want? Every time the goalposts are being shifted, sometimes contiguous, sometimes adjacent will also do, sometimes not. Both of them will not suffice. This is what is called, my lord, will come to the readiness and willingness to perform. Now, the person maybe have the capacity, he need not have to have a check, carry a check around that I'm ready to pay amount as you demanded. But the willingness to perform has to be as per the contract, what has been contracted for. The goalpost cannot be shifted that now I want something more. Therefore, you must be, I am willing to pay for that additional amount which was never in the contract. If that be the case, then a person with means can literally shift the goalpost around and ask the builder, deliver me this, deliver me that, I'll be willing to pay. That is the submission, madam. And this option was given to me at the time of booking. Changes that have been done in the 3-bedroom flat to be corrected and converted into the original 3-bedroom flat. Now he says that changes that have been done in the 3-bedroom flat of his wife, which is required to be corrected and converted into the original 3-bedroom flat. It is now unrecognizable from the earlier 3-bedroom flat he has got. Because of the construction changes he has made using the site engineers to make it a one contiguous unit. So he has now requested me as a builder that you revert back the changes that I made and make it again into a 3-bedroom flat. Again, my lord, there is no consistency in what exactly he wants. He has not stuck to one single demand. The multifarious demands, and at different point of time, the demand keeps changing. I will agree with your proposal if you kindly allot 4 private independent car parking space in the front. Earlier it was 1, now again 4. Every time the demand keeps changing, goalpost keeps changing. Earlier, I was willing to pay only the price of rupees 33 lakhs for a project. This price was offered to me by Utpal Das director, provided we made an advance payment. But now Utpal Das is no longer in our organization. So I've decided to pay according to the price quoted by Meghmalla Private Limited at the time of booking. This is a unilateral, he is changing the contract. Sometimes he's saying, I want to pay 33 lakhs. Now he's saying, I want to pay the price at the time of booking. 9 lakh 30 plus another 12 lakhs. That is what I want to pay. My lord, his wants and desires are multiple, my lord. The price list, terms and conditions and brochure were given to me at the time of booking. I'm also not going to ask for any discount for the advance payment we had made. So a cost of our project as per the price quoted by Meghmalla at time of booking will be as follows. This is what the total comes out to 41,96,475. He has set the price of the 3-bedroom flat at 21 lakhs, a 2-bedroom flat at 14 lakhs. 4 cars parking space, valuation of the 4-car parking space, society's fees. These are all unilateral valuations of the things that he desires. We have already paid 30 lakhs till date. If you agree to my proposal, we will pay rupees 5 lakhs immediately. The rest of the balance will be paid at the time of completion of the project and handing over the conveyance deeds. Therefore, there is a contingent readiness to pay. If I agree to his proposal to modify the original contract, then he is willing to pay whatever balance, according to him, rupees 5 lakhs is made. So this correspondence literally gives up multiple beliefs, and this is in 2009. This is prior to institution of a suit. These are recent correspondence prior to the institution of suit, which gives an idea as to what was going on in his mind, the grievances prior to institution of the suit. Now, my lord, will come to the pleadings in the suit. I'll refer only to particular pleadings, paragraphs, just to show what was in his mind prior to the suit and what actually was claimed at the time of filing of the suit. My lord, will come
Now,
to...
should we dwell so much on what was on his mind? That board has sailed now. We are now on what is to be paid back.
What is to be paid back?
Yes.
So, my lord, that is what is to be paid. If the written statement, in my written statement, what have I stated is at page 41 to 50, I can refer it to that. The amount which my statement is that at page 43.
The court below has held that specific performance is not possible.
Not possible.
So we are agreed on that. So, all right. So it is now only a question of reparation.
Paragraph 6. Page 43, which is paragraph 6 of the written statement. What is the amount that I have admitted as receiving from him. That in the answering paragraph 6 of the plaint, it is submitted that the respondents received payment towards cost of a 3-bedroom flat from Dr. Madhumita Das Mazumdar, his wife, rupees 7,45,762, and 154,238 towards the so-and-so Society Corpus Fund GMC holding external electrification, total amounting to 9 lakhs. In respect of his wife, not in respect of this particular plaintiff. Amount received Dr. Kishore Kumar Das towards cost of 1,000 square feet is 6,47,700 and 52,300, total 7 lakhs. It is learned from the site engineers that the plaintiff has incurred cash expenditure around rupees 14 lakhs for the internal construction of the 3-bedroom flat directly by the plaintiff within the knowledge of the site engineers working at site. The company has received only 16 lakh in total from the plaintiff and his wife as stated herein above. So the site engineers, there is just averment that they have incurred cash expenditure of 14 lakhs. For this particular 1,000 square feet I have got only 7 lakhs from the sale consideration. 2,30,000 from the agreed upon sale consideration is still pending. And the remaining, so total comes out to 9 and 7, 16. So 14 lakhs is towards the modification. Now my lord will come to, there is an exhibit which gives the payment of the 30 lakhs. This is at page 89. Well, we note the language. Exhibit 12 received an amount of rupees 30 lakhs, only page 89.
Page 80?
Page 89. Received an amount of rupees 30 lakhs only from Dr. Kishore Kumar Das and Dr. Madhumita Das Mazumdar on account of purchasing flat in our project so-and-so at Jatia Kailipura Road, Gauhati. This is some Gautam so-and-so from Megmala Estates and Services Private Limited. One line single statement from both plaintiffs. There is no mention of who paid how much against what head of construction was it paid. And this has been sealed and said that receive rupees 30 lakhs only. Now the question is, again, I will have to come out to whether they have been able to prove that they are paying a particular amount towards the sale consideration. Received, originally what we note is when we get the money received rupees X amount of money towards sale consideration for flat number so-and-so from particulars. That is the mandatory, which is general format, which I. Out of the blue, this agreement, this receipt comes on 30th of 30 lakhs, which is dated also, you know, the note. Hardly, there is no mention of any date. Now, and again, my lord, these are checks. If a 30 lakh has been paid by utilizing loan on legitimate expenditure, usually the payment method is by way of a check, so that the person who is paying can also keep track of how much has been paid. If the husband is jointly managing his wife's accounts, then even then it is paid by check. The husband is a power of attorney holder. He pays from his accounts, even then it is paid by check, so as to keep track of these transactions. This is not only for my interest, this is for their interest as well. In today's days, the income tax authority says, if they ask them, at that time they did not ask. But if they ask them that who has been paying this amount of money, why are these cash transactions being made? Ordinary rule of prudence is to pay by check to ensure traceability. They have not, in fact, they have not even given the traceability of the what 30 lakhs has been paid and to on what account. We have received checks. We are able to prove 7 lakh and 9 lakh we have received in the company account. That we are able to prove. Of course, I have not annexed that in the company account, but I'm also able to prove it from the company account if required. That 16 lakh has been directly deposited in the company account. Now, tomorrow the cash payment is made to an employee of the company for different fittings, fixtures. I have no control over that. Unless, of course, it reflects in the agreement that any payment made to the company or agent of the company would be deemed as payment towards the consideration. And again, it is reflected from their letter as well that in 2009, they were aware that two of the persons who site engineers who were making the alterations and fittings, they had already left. Already left. So in this manner, my humble submission is that my receipt is 7 lakhs. But if they're able to show that this is 12 lakhs has come specifically from the account of the plaintiff, I cannot deny that. It has to be an account to account. Somebody or issue takes money from them, and even then, they have not leveled a single allegation that so-and-so employee or agent took money.
So how has the learned trial court arrived at this figure?
At this judgment, my lord, may come to the, because the others are regarding joinders. So issue number 1, maintainability of suit, we need not go into that. Issue number 2, misjoinder, we need not go into that. Issue number 3 at page 129, again, defendant number 3 is not bound by the terms of the registered agreement. He is not being a party to that said agreement. They have relied on the actions of one Utpal Kumar Das and the assurances given, who was the previous director of the company, who assurances made therein. Who is the defendant number 3? He was not even a party to the agreement. So issue number 3 is also again decided against them, that he's not, defendant number 3 is not bound by the agreement. It cannot be enforced against him. Issue number 4 is, since this is an, if I read the entire one, since this is the issue related to specific performance of registered agreement for sale dated so and so, I have gone to the contents of the said document with due circumspection. On page number 2, it is written on application of the second party for allotment of 1,000 square feet in the ground floor Megmala Hillview, on being agreed by the second party so and so, on the share of the land and consideration charges including raw materials which will be fully paid as per schedule. The agreement in question was entered into by defendant number 1, represented by defendant number 2, and plaintiff on the terms.
Okay,
and
that is
conditions.
that is not in dispute.
That is
Issue
not in
number
dispute.
4.
Perusal of the plain discloses in para 5 thereof that it has been pleaded that the basic idea behind purchase of 1,000 square feet was, along with frontage area of approximately square feet, was that open up a doctor's chamber. That is again not in dispute. Now, Exhibit 8, speaks nothing to the effect that the plaintiff intended to purchase 1,000 square feet of ground space, specific purpose of setting up a doctor's chamber. Only speaks of 1,000 square feet of open space. That is also not in dispute. 35 and 36 regarding the GMDA bylaws, again not in dispute. Laws have changed, so the ground floor permission cannot be altered. Issue number 5. Perusal on facts. Perusal of para 4, the plaint shows that the plaintiff has pleaded defendant of 2 assured there was 99% chance that permission for construction of so and so would be granted. If by chance the said permission was not granted, the defendant number 2 and 3 promised the plaintiff a contiguous 2-bedroom apartment on the first floor along with 3-bedroom apartment to be booked in the name of the wife of the plaintiff would be given to the plaintiff at 14,94,200. This is one allegation. The 14,94,000 comes from the contiguous bedroom, which if they were assured to be get. Now, from the above averment, it was assured that there was 99% chance of obtaining NOC. It is abundantly clear that it was within the knowledge of the plaintiff since very inception of negotiation that the construction of ground floor space was subject to approval, may not obtain the permission for conversion into a doctor's chamber, and that is why there was alternative proposal of providing 2-bedroom flat in the event of not getting approval. It is pleaded that the defendants committed fraud as they never applied for permission. In this respect, the plaintiff applied again this matter that this is again relating to the with that bona fide conduct before the GMDA. So these laws do not permit GMDA. There was the Honorable Court held that there was no fraud or attempt to defraud, cheat the plaintiff. It further appears that while Exhibit 27, the defendant number 2 accordingly informed to the plaintiff that despite the best effort to get an NOC for converting the ground floor to an enclosed semi-finished space, they did not get the same. By it said Exhibit 27, an option was given to the plaintiff either to retain the ground floor as is various condition or cancel the agreement, enabling them to return the amount paid by the plaintiff. Further, it was also informed the plaintiff that in the alternative, the defendants could provide 2-bedroom completed flat, not semi-finished, on the first floor on a revised pricing. Said offer would remain valid up to 28 February 2009. Now, as per plaintiff, it reveals from Exhibit 28 that the defendants agreed in case NOC for ground floor space is not possible, they would provide a 2-bedroom flat contiguous with 3-bedroom flat allotted to his wife. However, it is clear on perusal of Exhibit 27 that defendants did not speak of providing 2-bedroom flat contiguous with the 3-bedroom flat allotted to the wife of the plaintiff, only of providing a 2-bedroom flat, not semi-furnished in terms of in lieu of the ground floor space. So, it is 46, paragraph 46. It is an admitted position that the defendants received 30 lakhs from the plaintiff and his wife. So, the Honorable Court accepted this payment receipt. $12 lakhs on the part of the husband. This is their own statement. 12 lakhs. The husband has said, I have paid 12 lakhs of the 30 lakhs. The wife has paid 18 lakhs. This is an admitted portion. Defendants received 30 lakhs from plaintiff and wife. Exhibit 12 is the acknowledgement of receipt of said amount from the plaintiff and his wife, but the same has not at all been disputed by the defendants. It is, however, contended we have disputed, meaning thereby we have said we have provided the alternative explanation. The payment may have been made, but it has not been made to our account. Therefore, this is a perverse recording of fact in the sense that in our written statement, we have mentioned that we have received 16 lakhs. 14 lakhs has been paid on their own account for payment.
You are saying from para 46?
From para 46. In my written statement, I have stated, yes, I have received 16 lakhs both from the husband and wife. The remaining 14 lakhs, they have spent on their own account to refurbish the flat, to make it a contiguous one-unit doctor's clinic. Later on, when they realize that the money has gone to waste, now they're asking me to restore the flat to this original condition, provide them another 2-bedroom flat, additional expense. It has contended received only 7 lakh and 9 lakh, and his amount of 14 lakh was directly expended by the plaintiff for the internal construction of 3-bedroom flat. However, defendant number 2 is admitted he has not given documentary proof to show that the plaintiff has incurred expenditure of 14 lakhs for internal construction within the knowledge of site engineers. These are things I do not know because obviously it is not paid to me. There is no evidence to the effect that the amount of 14 lakhs was expended for internal construction of the 3-bedroom flat. It rather appears that there is only one bill amounting to 13,362 for extra work. So my lord may understand a flat with substantial changes has been made and now it has to be restored back to its original position because it is unrecognizable for original position. 13,362 is a believable amount that only 13,362 was incurred in completely transforming 2 units into one. From exhibit so and so, it is duly proved plaintiff has paid 12 lakh in view of impossibility of performance with plaintiff entitled to refund thereof with interest. So there is only one basically payment receipt of 30 lakhs lump sum. And that is also not signed by appellant or anybody else. It is not signed on it is not dated.
In what manner did you dispute this exhibit 12, 30 lakhs before the trial court?
Hello, that for that matter, I may read my evidence. Me permitted to take on my evidences. In the cross-examination, the PW1, the cross-examination, I have taken certified copies of the cross-examination. If I may read it, I'll hand it over the certified. On oath, the cross of the PW1 on 15/9/2012. I came to contact with the defendant numbers 1 and 2, appellant saying, through Utpal Das, the defendant number 3.
This is cross of DW.
This is PW1, the plaintiff.
Yes.
I came into contact with defendant number 1 and 2 through Utpal Das, the defendant number 3. I have no previous acquaintance with defendant number 2 previously. I have entered into one agreement into defendant number 1 for myself and another for my wife. The agreement was entered on 6 July 2007 by Exhibit 8 and 9. I've entered into an agreement with so for the area of 1,000 square feet for a consideration of 9,30,000 again admitted. 9,30,000. The consideration amount of the amount written by my wife for the first floor flat A1 flat 101 is rupees 13,50,000, 13,50,000. So 930 here, 1350 here for the flat. I have filed the title suit individually for me. In my plaintiff paragraph 11, I have given a statement stating schedule of payment, payment for myself and my wife. He has given a paragraph of payment schedule. In my affidavit also, I have given a combined statement of myself and my wife stating payment schedule. Before signing the agreement, I have gone through the site plans, defendant number 1 for the suit property. The suit project is residential cum commercial one. My space is a commercial one. In the agreement, again, my lord, when it comes to the agreement of the wife, that is a residential property. He has admitted my space is a commercial one, ground floor space, which is 1,000 square feet. I do not know as to whether the space allotted to me was handed over to any other person. At the time of agreement, I was informed that defendant number 1 to have applied for NOC with GMDA. Defendant number 2 gave me the assurance of handing over 1,000 square feet of space as per agreement. So again, there's an admission of handing over 1,000 square feet of space as per the agreement. I cannot say why the defendant number 1 and 2 failed to hand over possession of the agreed space to me. On failure to provide space at the ground floor, the defendant number 1 and 2 has offered to provide a 2-bedroom flat of 1,000 square feet. The said complex as contiguous flat at the same floor, but I did not take possession of the same. Again, there is a contradiction here. He says they have offered to give me a contiguous 2-bedroom flat on the same floor, but I did not take possession of the same. As on there. Flat number A1 was allotted to my wife. It is a fact that due to existence of staircase, it is not possible to provide me adjacent flat with A1. The defendant number 1 and 2 has informed me about this failure to procure the permission for construction of ground floor. The builder has also intimated the fact of change of law as a ground of their failure to provide the agreed space. It is not a fact that defendant number 1 and 2 has played foul play with me. It is not a fact that defendant number 1 and 2 are not at default and I'm entitled for compensation. Now this is continued the cross-examination. Defendant number 3 and myself are relatives. The director is a relative. That is why he is acquainted. He did not know the defendant number 1 and 2. He knew the defendant number 3 who was then at the time a director. I'm aware that defendant number 3 was one of the directors of the defendant company, resigned from the post of director, the company, on or about 2008. Both the defendant number 2 and 3 informed me and my wife that in the event of non-granting of permission of GMD with respect to the modified approval plan, we would inform you accordingly. This assurance was given to me in the year 2006. The defendant number 3, so there is also an assurance that he will be informed in 2006. They give an assurance that in case it is not given, permission is not given, we'll inform you accordingly. The defendant number 3, while holding the directorship of the plaintiff company, assured me as aforesaid, but subsequently in his resignation as director, he informed me that the managing director would carry out his promises as assured herein above. So it is not my promise. Continue. Somebody on my behalf has made an assurance.
My lord, item 20, my lord, I beg to mention item 20.
Yes.
My lord, the other side is present.
Lordship, I'm for the appellant.
We are for the respondent.
When do you want?
My lord, 2nd of April.
Item 20.
Deeply of measure.
Method assembly. What the hearing assembly? What are you to consider? Method assembly. I think Mr. Das is there. How long would we take in this matter?
Will take, because there are.
Mr. Das, you are in item number 19, I think. We don't know how long this will take. Up to you. No, if you like, we can have it on another day. Fine.
In this case, I have read about that for cross-examination. In this case, regarding the expenditure of 30 lakhs. So there is an admission in the cross-examination, I'll correct myself to a limited point, that exhibits 17 and 20. These exhibits 17 and 20, these are at page 93 and 95 respectively. In this, the appellate, defendant number 2 appellants here, they have admitted that this exhibit 17 and 20, they have paid via them to the company to the site engineer.
This page?
This is page 93, my lord will take 93. Page 93 first.
Yes.
Page 93, this payment of 1 lakh from Dr. M.D. Mazumdar, payment of 1 lakh, 1 lakh again. This has been received. The top right hand corner. That, so I have admitted that signature. Defendant number 2 has admitted that signature in 93 in his cross examination, as well as the exhibit number 20, which is at page 95. So that is, there is the signatures of defendant number 2. They have admitted in the cross examination, I have admitted that yes, these are payments routed through me, not for payment towards the sale consideration taken the specific plea, but towards payment for the internal construction work, and they have admitted. The other payments, they do not carry my signature, the signature of the managing director. The payment received of 30 lakhs, the broad payment received, carries the signature of one Gautam Goswami. He said he's an office executive, not even in holding a managerial position. So that point is there. So the first point that I raised is regarding that 30 lakhs payment. This ought to have been segregated. If the learned trial court decreed the suit for 12 lakhs, alternative relief of 12 lakhs, there ought to have been some proof of how much of the 30 lakhs was actually paid 12 lakhs by the plaintiff in question. Because it has relied wholly and solely on the 30 lakh payment receipt, which does not mention that 30 lakhs out of this X amount has been paid by the plaintiff in one suit, Y amount has been paid by the plaintiff in the other suit. It's a mere blank lump sum receipt of 30 lakhs. Even if I admitted that 30 lakhs has been paid, the 30 lakhs, the contents thereof do not prove that 12 lakhs has been paid by the present plaintiff and 18 lakhs by his wife, even if it is admitted in it, accepted in evidence. That is my first point. Second point is that upon the exhibits which are other letters, the other receipts, they do not bear any signature or seal of the authorized signature. Merely assigning a signature received so and so by one employee, an office executive or an office peon, would not amount to proof of deposit, more particularly in respect of the sale consideration. This is the submission. That is why on the limited ground the appeal was filed. In this case, because the suit for specific performance was rejected, but the alternative relief was decreed of 12 lakhs. And the second point, which
you are bringing in other evidence, all right. These exhibits 17, 20, these you have admitted. But with regard to that, what was the 30 lakh exhibit? Exhibit 12.
Exhibit 12.
Yes.
If I may,
because the learned court has held that to be admitted.
We admitted.
So you have to show from your cross-examination that it was not admitted.
From a cross-examination, if you take up the cross-examination, I will simply read the cross-examination. Particularly with reference to
Who exhibited it? PW?
DW1.
No,
by
no,
cross-
this 30 lakh, who exhibited this receipt?
PW1.
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 So you show from cross of PW1 how it has been disputed.
Talk about the PW1. PW1. Admittedly, this PW1 has in his cross-examination regarding the payment of that I had read, Your Lordship. I'll have to read again.
Specifically with regard to that exhibit.
Specifically with regard to that particular exhibit. Go through that. No specific impugnment, assailment to that particular statement of that exhibit 30 is true. That is also the ground which has been taken by the learned trial court below that they failed to assail it. That is true. But
anyway, continue.
So, and on the interest part, my lord, that given that the agreement specified that in the event of failure of the promoter or developer to not be able to allot the property for any reason whatsoever, the amount will be refunded at the rate of 10%. The trial court gave at the rate of 12%. But from the date of the institution of the suit as well. My humble submission in that regard is that letter which I have read out of 2009, the February 2009 letter, it clearly shows that even prior to the institution of suit, all the parties were aware that it was no longer legally permissible to convert the ground floor space into any kind of commercial space, whether for doctor's clinic or for any other purpose. The ground floor had to be open space. It could be used for parking, it could remain open. The permission was not feasible as of February 2009. Therefore, to file a suit in 2010, claim again for the same relief which the plaintiffs themselves knew to be legally impermissible in law, and thereafter be entitled to be interest for the pendency of that suit filed by them, well, that is not sustainable manner. But let them, if the agreement allows for refund of interest at the rate of 10%, I cannot object on that on the agreement count.
Why was 12% awarded?
In the decree.
Where from did that figure come?
12%, there is no mention of why 12%. Why 12%? It is in the order. Suit is decreed on contest with the following relief. Plaintiff is entitled to recover sum of 12 lakhs only for defendant number 1, with interest at the rate of 12% per annum from the date of filing of the suit till the date of decree. And further decree for realization.
The agreement, it is mentioned 10%.
Agreement, it is mentioned, there is a clause which I read.
So regardless of the point of time from which it is to be paid, this 12% is because the agreement, in excess of the agreement. Okay, now as regards the point of time.
They were aware in 2009 that it was legally impermissible. 2 of the release were automatically unsustainable in law. They cannot now take the plea of
the money was with you. Did you offer to repay immediately? You did not repay it at that time.
That is the point. They have also immediately acknowledged in their pleadings that I had offered that I had given a final reminder that on as is basis take the ground floor space or take the refund of the money with interest. It is in their pleadings. But they did not take it because they felt aggrieved by the fact that an injustice had been done apparently to them. They wanted the entire unit, first floor and second and ground floor, as for doctor's clinic. Thereby, they had claimed for damages because their business plans had been thrown off gear. I had made the final offer on 28 February 2009, I believe, that if you desire to take the ground floor on an as-is basis, take it. If they do not desire it, then the money has to be obviously refunded to them. I cannot take the money. That would be extortionate. I'll point out where have I taken that plea, the particular page. I'll point it out.
Is that specific line there in your communication that take back the money?
Take back the money. I would be treated.
Because from the time you accepted the money, you were enjoying the interest on that money.
Yes. On 10 February 2009, there is a statement. 10 February 2000. Page 105. Page 105. This is reference to subject matter of best effort to get an NOC for converting the ground floor to an enclosed semi-furnished space. We could not get the NOC. Hence, it will not be possible to convert the ground floor to a covered semi-finished space. In view of the above, we would like to give you an option to either retain the ground floor as is various condition or cancel the agreement, enabling us to return you the amount paid to us.
Dated?
10 February 2009. Alternatively, we can provide you with a 2-bedroom completed flat, not semi-finished, on the first floor on a revised pricing to cover the cost of finishing work on the flat. We give you time up till 28th of February 2009 to give us a written confirmation on the above alternative arrangement. Thereafter, my lord, that letter came in 19 February 2009, whereby they exercised the option of both having the unit as well as exercising the simultaneous option of having a contiguous flat. And again, also exercise the option of what we had given them earlier. 3 options they took, which I had read before, Lordship, that every time they were not even sure fixed that we want a particular specific option. They literally asked for 3 different options and gave us a payment schedule of 41 lakhs, which they were apparently willing to pay. For obviously, being this, I had given a proposal, A or B, take option A, B, or alternative option C. They returned me a counter proposal saying that if my desire is for A, if you can't give me A, I want B at a particular fixed rate, revised rate, I want C at another fixed revised rate. Thereby muddying the waters, they have muddied the waters themselves. They could have been clear and categorical that we would not exercise the option, we want option A or option B or options. There, in the letter, this is the subsequent letter, page 105 and 106 is the letter, and 19 February, they have not categorically even mentioned which of the option they would like to take. One option they have clearly ruled out, they do not want the space on an as-is basis. As per the agreement, they do not want the space. That option they have ruled out. What have they actually said? They have stated that if it is not possible to provide me the ground floor space because of not getting permission from the GMDA, I'll be satisfied with a 2-bedroom contiguous flat. Admittedly, there is no contiguous flat. This is the first time they have raised another option. Changes that have been done in the 3-bedroom flat to be corrected and converted into the original 3-bedroom flat, which is not again what the proposal I had given. Is a counter proposal. I will also agree if you allot 4 private independent car parking space, another counter proposal. Offer is to be accepted in totality or not at all. Counter offer becomes another new proposal. I will have to, therefore I deemed it that they had not accepted my proposal of 10 February. I cancelled the allotment.
According to your interest, assuming it is to be paid, from what point of time interest is to be paid?
Interest point of time from the date of demand of the refunded money back. The question is not
Which was that?
They have never made any prayer for demand of 12 lakhs.
Then from the date of institution of the suit, at least, in the suit that prayer is there.
In the suit, the prayer is there for 41 lakhs with interest.
Whatever, the return of the money is there.
Return of the money. But on the other hand, 2 of the prayers in the suit are again barred by law from the inception, which they know beforehand. 1 year prior to filing.
That doesn't involve the question of interest, date from which interest is to be paid.
But delay question is involved.
Since your answer is that it is from the date of demand and there was no prior demand prior to institution of the suit, So it will probably be from the date of the suit, institution of the suit then.
From the institutions. But then again at 10%, because the
Percentage is of course a different matter that we'll have to see what is there in the agreement.
the agreement is the 10%. That agreement, if agreement is 687. The particular clause is clause 4. Company shall refund the amount deposit with simple interest at the rate of 10% per annum. Page 70.
Because it is clear that whatever be the amount, some amount you have to return.
Yes, the amount I have to.
So therefore, it is important that we have to come to a finding as to the point of time from which interest is to be paid.
Interest is to be paid. That I will leave to your lordships on the basis, because it is again a question of discretion to be exercised on the basis of the facts. The amount of time spent, the cause for litigation. My only point was that if they had demanded the simple return of the deposit, I would have no case. The agreement says I have to return the money deposit if I can't give the property. Any delay caused in return of the money deposit is solely on my account. When there is a revised claim as well as 2 reliefs that are barred by law, ultimately, my lord, they have contributed to their own difficulties. That, in fact, the first floor flat that was purchased at purportedly 18 lakhs. Consideration was 13 lakh 50. They have paid 18 lakhs. As on date, even if that flat is disposed of, they are getting back double their money. No loss as such. Only loss is there is a protracted litigation, which they raised bar claims. This is the regarding so far as the RFA 160. I conclude my submissions on RFA 160.
Would be the price of the property now.
In localities such as Kahilipada, yes, that would be, it is not a 10, it is a 10-12-year-old flat. It would be double. They would double their money.
Yes. So you missed out.
Is it now in Shabels? At least they could have handed me over the other flat. There also they took a stay.
Yes.
So far as RFA 119 of 2017 is concerned, my lord, in this case, the difficulty that I would obviously be facing is that as an appellant, the appellant did not file the written statement in the plaint.
Come to that later. I think we should complete this one first.
Well, so far as my submissions on this is concerned, these are my submissions. I'm winding up my submissions on this. I would reserve my reply on the cross objection and other submissions made. Or if my lord desires to hear my learned friend first on this issue.
Yes, before we get confused further.
That would be true. You can on this suit.
Hey, please. Lord, first of all, I must clarify a few factual positions. But a lot of arguments have been raised, but they do not really find basis in the pleadings of the parties. Now, if your lordship will kindly have the plaint.
Yes, plaint.
I'll refer to the paragraphs in the plaint and also the corresponding replies in the written plaint. Your lordship finds from page 8, Mullah, the body of the thing. Begins at page 7. Indicate the relevant paragraphs, Mullah, and their corresponding replies in the First, if your lordship has paragraph 3 at page 9. Original understanding, according to me, whereby they had agreed not just to hand over 2 apartments, but also a frontage, which my learned friend has now disputed that that was never the arrangement. Some contradictions are sought to be pointed out insofar as the other letters are concerned. Now, para 3 is that averment as represented to the plaintiff. The defendant is a company which is engaged in the business of real estate. The plaintiff and his wife, MD Mojumdar, who is a senior consultant gynecologist, being interested in opening up a doctor's chamber cum clinic, had approached the defendant number 3, was then a director of the defendant number 1, for purchase of an area in the Meghmalar Hillview apartment situated at Jotia Ganeshguri. On 18/6/2006, the defendant number 3 informed the plaintiff and his wife that in the said Meghmalar View apartments, on which construction was going on in full swing, the defendants can provide a ground floor measuring 1,000 square feet plus frontage of approximately 400 square feet and an area of 1,375 square feet in the first floor. It was further informed that for the ground floor space of 1,000 square feet, an area of approximately 400 square feet of frontage area, the first floor 1,375 square feet along with registration costs shall come to rupees 33 lakhs, provided the plaintiff and his wife made advance payment of the said amount. It was mentioned rupees 33 lakh had been quoted for the entire area as stated above. So that is my averment, ground floor, first floor, and a frontage of 400 square feet. If your lordship will kindly take page 41, the reply to this particular paragraph.
Yes.
Paragraph 3. That the paragraph 3, that the answering defendants admit the contention of paragraph 3. So it was an admitted position, no point raising a ground today. Now, insofar as the ground floor is concerned, again, if your lordship, can I trouble your lordship to come back to page 10 again? The plaintiff and the wife were thereafter taken to the defendant number 2 by the defendant number 3 in order to finalize the deal. At the time of finalizing the deal, the defendant number 1 and 2 stated that the price of the entire area, which included the ground floor space of 1,000 square feet plus an area of approximately 400 square feet of frontage area, the first floor area of 1,375 square feet, which corresponds to a 3-bedroom flat, along with registration costs, etc., shall come to 33 lakhs. It was, however, mentioned that the permission for construction of the ground floor space of 1,000 square feet, though have been applied for, but have not been received from the GMBA authority. It was further informed that the permission was a formality, and defendant number 2 assured that there was a 99% chance that the permission would be granted, and if by chance the said permission was not granted, the defendant number 2 and 3 promised the plaintiff that a contiguous 2-bedroom apartment on the first floor along with 3-bedroom apartment to be booked in the name of the wife of the plaintiff would be given to the plaintiff at rupees so and so. Now here, of course, they fall back. I'll just read out page 41 again, the reply to this paragraph, that the answering defendants do not admit the contention of paragraph 4. They submitted, though it was verbally accepted that 1,000 square feet ground floor space may be provided subject to approval from GMDA. The defendants never gave any assurance or entered into any agreement with the plaintiff to provide a 2-bedroom flat contiguous. This is para 4 at page 41. It spills over to page 42. Then, my lord, if I may just take your lordship to paragraph 5 at page 42, that's their moot defense. That we cannot construct it because there's a particular bylaw which mandates that the ground floor should be reserved for parking. There cannot be any constructions thereupon. So that is at paragraph 5. That is the whole and soul of the defense insofar as the defendants are concerned. Now, paragraph 7, 8, and 9 are regarding how allotment letters were issued and the agreements were finalized. Now, paragraph 11, this is part of paragraph 11. If your lordship comes to paragraph 16, page 16, I'm sorry. Page 16. Your lordship finds a table. Now, your lordship will mark this sort of answers the question raised by my friend that we aren't sure as to how much was paid on account of the wife and how much was paid on account of the plaintiff. So in this table, we have shown the bifurcation of all the payments in respect of the plaintiff and also in respect of the plaintiff's wife.
This is page 10.
This is page 16.
16.
16. I'm referring to the page numbers on the top right.
Yes, yes, okay. Running page.
Running page, yes. So this is the table. There's a clear demarcation of what was out of the payments, what was on account of the wife's allotment and what was on account of the plaintiff's allotment. If I may just point out, my lord, this entire argument that the decree was passed on only on the basis of that composite receipt of 30 lakhs is actually not correct. For each of the transactions, there are separate exhibits for each payment that is made against the name of the allottee, and also specifically mentioning that it is for purchase of a flat. Now, if I may just show, so which is why at page 46, your lordship may have noticed the trial court had also said exhibit 4 to 22. These are a series of receipts, individual receipts. So I may just show from the document, page 90, for example. Page 60, page 63 for once. Three. Received with thanks the sum of rupees 2 lakhs only from KK Das on account Jotia on 12/2/2007. So this entry of 12/2/2007 figuring in the table has a corresponding exhibit. Likewise, if your lordship now has page 65, page 65 again is a different receipt for the wife. So for all of the entries that are there in that particular table, there is a corresponding receipt which shows that the payment was made on whose behalf and against which allotment. So this entire ground is without any basis. We'll shortly do the math and we'll indicate the exhibits. For each of the payment that is made, there's a separate receipt. And exhibit 12 was just a comprehensive receipt that you've paid in total this much. So now, before I take your lordship to the other receipts, in fact, there are a series of receipts from exhibit 4 to 15. And some were not included in the memo of appeal, which is why we filed an IA to bring them on record. Otherwise, they are there in the LCR also. Now, before that, if your lordship may kindly have the response to para 11, which your lordship will find at page 44. Now, this is the response to that paragraph containing the table of payment. First of all, of course,
Page 44.
page 44, para 12. I may read, my lord, that in reply to the statements made in para 11 of the plaint regarding obtaining no objection certificate from the concerned authority, the respondents personally approached the concerned authority for allowing the permission for 1000 square feet. It was learned that there was no such provision in the revised building bylaw to give necessary permission other than the parking space and open space as provided in the bylaw. Hence, the respondents did not approach officially to the concerned authority for obtaining the no objection certificate to use the 1000 square feet space for clinic purpose other than parking area. It is an admitted fact that the plaintiff was well aware the fact that no objection certificate cannot be obtained to utilize the space of 1000 square feet for any other purpose other than using the same as parking space. So the plea is that I knew that there cannot be a flat and I had purchased the parking space of 1000 square feet. That is their defense. Hence, the plaintiff agreed to take a 2-bedroom flat, but not contiguous to the 3-bedroom flat, as there is no such provision planning having contiguous 2-bedroom flats with the 3-bedroom flat. Then the subparameter at page 45. Further, the payment schedule shown in the plain is not in agreement with the account maintained by the respondent. It is submitted that whatever excess amount shown to have been paid to the respondents were expended directly by the plaintiff towards interior modification of the flat within the knowledge of the site engineers for completion of the 3-bedroom flat 101. The respondents deny receipt of rupees 12 lakh from the plaintiff and 18 lakh from the plaintiff's wife. The defendants have only received so and so and so and so. So basically, the payments per se are not disputed. They say that these were whatever additional payments are shown over and above 9 and 7 were expended towards interior works. And this is the reason why the trial court has again discarded that. Where is your evidence to show that this was not in account of the flat? In fact, my lord, there are a few printed receipts which have actually said that this is against the flat. For example, if your lordship may have page 94. This says, receive with thanks from so-and-so, rupees 3 lakhs by cash, check, etc., on so-and-so drawn on SBI Bank on account of purchase 1 3-bedroom flat at Jotia Ganesh. So there are also receipts which are clearly indicating that this, I mean, that is the only arrangement that we had. And ground floor, what renovations and all do not arise because the ground floor flat was not even built eventually. It was an empty space. So the argument that so much of renovation was made so as to club the two apartments. The ground floor apartment was not even there. It's not there till today. So therefore, considering the fact that there was a vague denial, number one, there are money receipts showing payment of each of the installments. There was absolutely nothing to show that this was on account of a separate independent transaction. The court rightly held that this is the amount. Of rupees 12 lakhs, and therefore they must sort of repay that with interest. So this is, if I may just pause here, Lord, this is insofar as the payments are concerned. They are just going nitpicking to find some loophole here and there. But insofar as the substance is concerned, that whether those payments were made, yes. Whether there were individual receipts in respect of the plaintiff and defendant, that's also correct, Mullah. Whether there's anything to show that this was a separate transaction, there's none, Mullah. So going by all of this, Mullah, that figure of 12 lakhs perhaps is now cast in stone, and therefore you cannot re-agitate that issue in a first appeal and say that the evidence was not proper. And these exhibits were never countered. I'll show from the cross-examination of the plaintiff that these exhibits were not even put to question during cross-examination. So insofar as the figure is concerned, no matter how much they try, I believe this is almost certain that we had paid 12 lakhs and the 18 lakhs for the husband and the wife. Now, so therefore, insofar as the decree for the principal sum is concerned, my lord, I believe there's not much to argue insofar as that is concerned. The other ground that the agreement in question envisages 10% interest and the court ordered 12% interest. So to that, I can even bow down because your lordship is aware of section 34, that if it is pursuant to a contract, then the court can also grant pre-trial interest, which the court could have granted. So if your lordship holds that I am just entitled to 10% from 2006, I have absolutely no objection. It will yield a higher interest for me. So be 12% from institution of the suit, as opposed to 10% from the date of payment, because that is the mandate of 34. Then I'll concede to that argument. Let there be 10% from the date of payment. So it will in fact yield a larger interest. And the remaining 6% is, of course, in tune with section 34 CPC. Therefore that remains. So 2017 was when the decree was passed. So if your lordship decides that it's 10% from 2006 to 2017, we'll be happy. Your lordship can set it aside insofar as 12% from the date of institution is concerned. Now, I believe, my lord, so far as the money part of it is concerned, so far the refund of the principal sum is concerned, that perhaps a fine fall with the judgment of the only insofar as interest is concerned, that your lordship can modify. But insofar as the principal quantum of the principal sum is concerned, there's hardly anything to dispute. My lord. Perhaps I will urge your lordship to answer a much larger question as to whether, besides the refund of the principal along with interest, should the court have also granted compensation to me? That is why the cross objection is filed. Now I'll just give a brief, of course, the agreement has been relied upon to say that we never, all we wanted was actually an empty space, and for that we were ready to shell 18 lakhs odd. And therefore, this agreement should be construed as an agreement for only an empty space. So that I believe is an absurd defense, in a sense that no prudent man would buy an empty space on as is various basis for 18 lakhs in a ground floor, which cannot be converted into a livable space. Now, for that, if your lordship has page 67, 67 is the agreement, Lord. And 69, your lordship, my friend has pointed out that what it mentions is 1,000 square feet on the ground floor. It doesn't mention super built up area or anything. But if your lordship sees the other clauses of the agreement, it clearly says apartment. clearly says apartment. Now, another clause I'd like to sort of point out is clause 19, which my friend had read at page 73, Manoj. The intending allottee agrees that if a result of any legislation, order, or rule, the company, after allotment, is unable to deliver possession to the intending allottee, the only responsibility and liability of the company will be to pay to the intending allottee the amount attributable to the apartment that may have been recovered by the company at the time without any interest or compensation of whatever nature and in the manner as may be decided by the company. And same as aforesaid, neither party shall have any right or claim against the order in relation to this. So this is perhaps the clause they want to rely on, that over and above the principle that you've actually paid, you're not entitled to anything else. This is the condition of contract. Now, my lord, clause 19, I would say, is actually assertion of the provision of law which governs such a situation of impossibility, which is section 56 of the Contract Act. Now, if your lordship may kindly have the contract.
This clause says no interest.
This clause says no interest.
Where is the 10% then?
10% is at page clause 4, page 7.
Page?
Page 70, clause 4.
70.
7. I would say, my lord, clause 17 is catering to a situation. Clause 4 is the general clause which says that if I can't deliver, I'll pay back the money along with 10% interest. Clause 19, in my understanding and in my view, operates on a different field when he is prevented by some law, regulation, rule after the allotment. That is when he's sort of absolved from paying interest or compensation for that matter. Now, but my lord, this particular clause, if it is read in conjunction with the provision of law that is there for contracts, my lord, concerning impossibility, in my respectful submission, this will fall on the second part of clause 50, section 56. If your lordship may kindly have section 56.
Yes.
So they now call it an impossibility because the rules do not permit, so therefore we cannot construct. Agreements to do impossible act. An agreement to do an act impossible in itself is void. The second part, a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So this part concerns a situation when it becomes impossible after the contract is executed. Now the second part, compensation. Compensation for loss through non-performance of act known to be impossible or unlawful. Where one person has promised to do something which he knew or with reasonable diligence might have known, and which the promisee did not know to be impossible or unlawful, such promisor must make compensation to such promisee for any loss which such promisee sustained through non-performance of the promise. So the third, the third part of section 56 is saying that something which was already impossible and the promisor already knew that there is impossibility, but he nevertheless induces the promisee to enter into the contract, then he is also liable to pay compensation. This is the premise on which the counterclaim has been lodged, and I will now try to show that the case covers by the third part of section 56. If your lordship may
If
have
you
the.
can show that they knew beforehand.
Yes, yes, yes. I'll show. I'll show.
About the GMC route.
Yes.
As a builder of repute, they
The builder of,
presume,
he's a builder.
presume to know.
Yeah, he's presumed to know. In fact, he's admitted in the cross-examination. Now, what had happened, my lord? Why did this dispute start? They said that we have applied, don't worry, we'll come back with the report. In fact, at page 98, they also shared plans. Page 98 of the memo, your lordship will find plans to show ground floor and first floor are there. So they're saying that we will eventually get this approved and you'll have a flat manure. Then when the dispute arose, first of all, they're apologetic. At page 105 for a moment, if your lordship sees. So till October 2008, they are conveniently sending plans that this is how your allotment will look like. And then on 10/2/2009, this is the first disclosure. This has reference to the subject of above. In spite of our best effort to get an NOC for converting the ground floor to a enclosed semi-finished space. So understanding is very much there, my lord. It was never that I was so naive to have purchased the blank open space. To a enclosed semi-finished space, we could not get the NOC. Hence, it will not be possible to convert the ground floor to a covered semi-finished space. In view of the above, we would like to give you an option to either retain the ground floor as is various condition or cancel the agreement, enabling us to return the amount paid to us. Alternatively, we can provide you 2-bedroom completed flat, not semi-finished, on the first floor on a revised price to cover the cost of finishing work. We give you time up till so and so to for a written confirmation on the above alternative arrangement. This offer shall remain valid on 28/2/2009. That is why we send that letter which my friend had read, that if that is the case, then give me this allotment, proportionate calculation should be this one. We are ready to give you this. To that letter, which my friend read, at page 109, your lordship finds a reply. This time, the tenor will change. Till page 105, they were apologetic. We tried our best to get it. We did not get it. Now at page 109, they now fall back on the agreement. Kindly refer a second paragraph. Kindly refer to the agreement subject serial number 1 and 2 above. Agreement in serial number 1 is for 1000 square feet on the ground floor. This is scheduled parking area as per approval received from GMDA. This is not a living unit. Agreement above is a living unit as per approval. We have already allotted the spaces mentioned in the agreements above to you. Please note, we have already allotted. You're saying we've already allotted, you take the empty space. Please note that the ground floor area of 1000 square feet can only be used as a parking space. No constructional work whatsoever is permitted at the parking area as per existing approval. You will not be able to execute a conveyance deed on the ground floor. Corpus fund or monthly maintenance are not applicable to you. This is, my lord. They say you check your agreement, it's only for 1000 square feet. You take, I've already allotted you 1000 square feet, but mind it, you cannot sell it also. What best we can do is you don't have to pay maintenance. This is the conduct of the builder. So, of course, that alternate arrangement, like my friend has said, did not work out. Ultimately, they held on to the money. Then when we filed the suit saying, give us specific performance or alternatively refund the money, they said that no, you've not even paid 12 lakhs, you've just paid 7 lakhs. Rest we've adjusted to some interior works. What possible interior works can happen in respect of at least this unit? I mean, this space. This empty space, you yourself said that you cannot do any construction, no sale, nothing. You just take this empty space for 18 lakhs and be happy with this. Now, my lord, the bylaw that was cited is the GMDA bylaw of 2006. No? Now, my lord, when this dispute starts brewing, my lord, we get a little curious. Did you know from before? Was this just a ploy? And to make sure whether he was actually bona fide in his transaction, we write to the GMDA in the form of an RTI to say that whether Meghmala had in fact applied for a permission for ground floor or not. Then the GMDA gives us a reply that no permission even has been sought for by the builder concerned. That is exhibit 38. I'll mark it later on. In the LCR, I'll mark it. And by this time, they've already taken 12 lakhs. Already taken 12 lakhs. Now, if I may just request your lordship to peruse the cross-examination. I may be permitted to read it. Cross of DW1, it is perhaps a flag mark. This is the managing director of me. I am in the business of real estate since 1987. I am not entirely conversed with the building bylaws. I am only aware that GMDA has building bylaws. I am not aware that GMC has its own building bylaws. I came to learn that there was a revision to the bylaws as regards parking only when I approached the GMDA for clarification. I approached the revision of parking relates to enhancing parking area by another 25% upon the existing one. I do not remember the date when I asked for the clarification. Then he says, it was much before 2006 that I sought clarification, and I'm sure. Much before 2006. By exhibit 8, the agreement dated 6/7/2007, the defendant number 1 agreed to provide 1000 square open square space in the ground floor to Kishore Kumar Das. It is not mentioned in exhibit 8 that the said 1000 square feet of open space is for parking only. It is my case in my written statement as well as in my evidence on affidavit that the ground floor area was only for parking, nothing else, my lord. The permission was obtained on 7/3/2006 as regards the signature exhibit 6(1) appearing in exhibit 6. I cannot say where signature it is, but as regards exhibit 6, I say that the letterhead of the defendant number 1, I do not certify the contents of exhibit 6. Exhibit 12, that is the exhibit which gave the cumulative figure of 33 lakhs, my lord, which has now sought to be disputed, my lord. Exhibit 12(1) is the signature of Gautam Goswami, who was working in my office as an office executive. Exhibit 13(1) is the signature of Utpal De, who was one of the directors in the company then. So receipts are now admitted. At least he says that these are my office people. Exhibit 16(1) is the signature of Utpal Kumar Das, which I recognize. I do not recognize whose signature is exhibit 17(1), and 27(1) is my signature. I did not file any application to GMDA. This is important I did not find any file any application to GMDA for converting the ground floor to an enclosed semi-finished space, so he did not even apply. It is my specific case in my written statement as well as in my evidence on affidavit that the permission given by the GMDA for the ground floor was for parking only. In that regard, I refer to para 12 of my written statement and para 9 of my evidence on affidavit. I had met the town planner with the GMDA. I had met him in the year 2006-2007. The name of the town planner was Dalim Gogoi. I had also met the engineer Sri Pradip Burman. Later on, the witness says, I do not remember the year in which I met the town planner and the engineer. I am not aware during which period Dalim Gogoi was there in the GMDA. I do not know whether Dalim Gogoi was a town planner in the year 2007, 2008, 2009. Later on, he says, I remember that Dalim Gogoi was town planner in the year 2008 and 9. In GMDA, the normal procedure is that before filing any written application, clarifications are sought verbally. I do not know whether I had asked Mr. Dalim Gogoi officially or unofficially. I learned about the revision of the bylaws only when I approached Mr. Dalim Gogoi officially. To court, according to me, officially means giving a written application and unofficially means verbal discussion. I am not aware that as per the GMDA rules and acts, unofficial communications can be made with the GMDA. I came to learn about the revision of the bylaws after I met the plaintiff. I do not remember whether it may be after the agreement or before the agreement. I do not remember whether before executing deed of agreement with the plaintiff, I had asked Dalim Gogoi for clarification regarding conversion of the parking space for another use. The next day's process, I'll just finish this if your lordship doesn't. I had taken permission from the GMDA for construction of flats. The architect informed me that unless I apply for fresh NOC to convert the parking into other usable areas, it would not be possible to convert the parking area into other usable area. The architect also informed me about the clause of the GMDA bylaws, which have been referred to in my evidence. Sri Rana Das was my architect. I incorporated clause 58.10.4 and 58.10.5 of the GMDA bylaws in my evidence as well as my written statement as per instructions of my advocate. From reading of the clauses of 58.10.4 and 58.10.5, I can say that ground floor cannot be converted into semi-finished area unless permission is obtained from the GMDA. After obtaining permission from the GMDA, I will be guided by the GMDA bylaws, and after taking permission of GMC, I'll be guided by GMC bylaws. I'm guided by professional advice of architects in getting permission as per relevant relevant clauses of the bylaws. My answer to the question as whether 58.10.4 and 58.10.5 require any interpretation before application is that it is this court to do any interpretation of law as is required, if any. My only point is that without a valid NOC, I cannot convert the parking space to any other usable area. We apply for the NOC by submitting the drawing as per relevant bylaws. By other empaneled architect for modifications or alterations of the approved plan are required to submit fresh application with fresh drawing from the architect, but not with respect to internal modifications. In the instant case, conversion of the parking into semi-finished or usable area does not fall within the ambit of internal modification. As such, fresh applications will be required. In the building bylaw in question, there are 30 units. The total constructible ground floor area is so-and-so square meter, which corresponds to so-and-so square feet. The term others in parking area appearing in plaintiff document number 1 means various facilities like staircase, left space, common lobby, servants quarter, society room, etc. I cannot say that it is for the architect to say as to what is the ratio of parking space vis-a-vis dwelling units as per clause 58.10.4 and 58.10.5. I have not adduced any architect as a witness in this case. I cannot say as to when the amendment was affected GMDA bylaws. When the plaintiff approached the defendant company, there was uncertainty as regards the parking requirement and also as regards alteration of the parking space to other usable areas. When the plaintiff approached the defendant with the idea of opening a ground floor clinic, we said that alterations can be allowed only after obtaining a fresh NOC. Exhibit 2 and 3 are applications given by the plaintiff for registering the name of the plaintiff and his wife. Exhibit 6 and 7 are allotment letters issued by defendant company to the plaintiff and his wife respectively. Exhibit 8 and 9 are agreement entered into plaintiff and his wife respectively. The price of the ground floor is so and so. The price of the first floor is so and so. It is that 1000 square feet area on the ground floor as agreed to in the agreement dated so and so is allowed to be converted. Then also it would have no effect on the planned parking space for 30 dwelling units. Exhibit 24 is the plan drawn by the engineer indicating pathways for the pedestrian to go to the lift and staircase. Exhibit 2 is the alteration drawing to establish direct connectivity between ground floor and first floor. Exhibit 26 is the drawing showing the parking staircase, lift lobby, security room, society room, etc. Exhibit 26(1) is the initial which I recognize. He said proposal. So he had also submitted the proposed drawing which I had just shown, which is Exhibit 26. The said proposal was given as an alternative proposal on 3/10/2008, and the same was open for discussion subject to obtaining of NOC from the authorities concerned. As regards the amount of 14 lakhs, which I have mentioned in para 7 of my evidence on affidavit, I have not given any documentary proof to show that the plaintiff had incurred expenditure for internal construction of the 3-bedroom flat within the knowledge of the site engineers working at site. The site engineer at the relevant point of time were so and so and so and so. Mrigan Chaudhary is alive. I do not have any contact with Biswajit. I have contact with Mrigan Chaudhary. The statements made by me in para so and so regarding expenditure done by the plaintiff is based upon my discussion with the site engineer. Exhibit 17 and 20, receipts given to the plaintiff for payment made in cash to supplies contractors, though the same are modifications done. Exhibit 17(1) and 20 are initials which I recognize. So the takeaways from this cross-examination in my understanding, number one, he is a builder of repute from 1987. He is in constant touch with the architects and the site engineers. He's had discussion, maybe verbally, etc. He says that he knew about these bylaws to 2006, before 2006. Then he, of course, tries to change and say maybe before or after, I may have forgotten. But he agrees that till 2008, he was sharing provisional plans where ground floor was shown as a usable space. Then, my lord, insofar as the payments are concerned, he recognizes the signatures of all the receipts that are there. He also recognizes the signature where the provisional plans were exchanged. And then he candidly admits that as per the rules, you have to submit a revised drawing, and that is how modifications are carried out in the plan. So without there being a formal application, there cannot be any consideration. On the same breath, he also says, but insofar as ground floor is concerned, I have absolutely no document to show that I had even approached the authorities. So given all of this, my lord, first thing, like I said, 12 lakhs is more or less admitted. It must be said, because the wordings used in 56 part 3 is that the person actually knows or may have known with due diligence, my lord. This was the least amount of due diligence he could have done, my lord. And over and above that, the conduct will show that he knew that there were no chances. He knew about the bylaws. But he is receiving payments till 2008. He's sharing provisional drawings till 2008. 2009, he makes a volte-face and says, no, the agreement is only for empty space. I have already allotted, you take it, but you can't sell it. If this is the conduct, my lord, and if we go by 56 third part, my lord, first of all, clause 19 also must be read because it says after allotment. So the rule which prohibits or makes the contract impossible has to arise or come to the fore after the contract. And a different interpretation would be in conflict with section 56 also. And therefore, even if it is assumed that after allotment may mean something else, then also 56 will prevail because there cannot be any estoppel against the statute, my lord. So given all of this, my lord, and now, my lord, the There was no construction at all insofar as the ground floor is concerned. So there is no question of me expending towards interior works. That is perhaps a plea that maybe you can remotely take in the appeal filed by the wife or that proceeding, my lord. But insofar as KK Das is concerned, my lord, there is absolutely nothing to show that there was any payment on account of any transaction, separate transactions concerning interior works, my lord. Now, we are all aware of the settled position of law that in a contract for specific performance, only the parties who are privy to the contract are necessary parties. In fact, Supreme Court has said even while parties have approached for impleadment, they have reminded that when it comes to specific performance of the contract, only the parties to the contract are necessary parties. And now here, insofar as this case is concerned, the agreement and between the builder and the husband is only in question. And the two parties that are there are within the area of parties in the suit. Manoj. And so therefore, there is absolutely nothing to show. It's a mere technical plea saying that your wife may have also paid, etc., etc. You may have deposed as a witness in your wife's case. How does it at all matter? So long as the transaction or the contract is independent, and so long as the parties to the contract are in the array of parties, there's no question of me making the wife a necessary party, Manoj.
Did you claim compensation in the suit?
Yes. Your lordship will take paragraph 27 onwards.
Of the plaint?
Yes, page 31. Paragraph 28, page 31. Without paragraph 28, Manoj. Should I read? Without prejudice to what has been stated herein above, the plaintiff alternatively states that if this honorable court is however not inclined to grant the specific performance, the plaintiff is entitled to recovery of the money already paid to the defendant along with interest accrued thereon, and for compensation for the injury caused to the plaintiff by the defendant as already stated herein above. The ground floor space more specifically mentioned in Schedule A to the plain was an integral part to the setting up of the doctor's clinic. The action of the defendants in duping the plaintiff in respect of the Schedule A area have made the plans of the plaintiff to set up a doctor's clinic impossible, thereby causing huge financial loss to the plaintiff. The actions of the defendants amounts to breach of contract for which the plaintiff is entitled to special damages as well as general damages. It is stated that the plaintiffs, after realizing the fraud committed by the defendant, upon him inquired with various real estate companies in respect of similar areas as mentioned in Schedule A to the plain, and could come to learn that the present rate is around 1,850 per square feet. The plaintiff had also suffered mental as well as physical agony on account of the illegal actions of the defendant. It is further stated herein that the plaintiff had invested hard-earned money to set up the doctor's clinic, and the illegal actions of the defendants have, apart from causing physical and mental agony, had also caused great financial loss to the plaintiff in respect to his professional works. The plaintiff pays for special damages for an amount of so-and-so on the following counts. Financial loss caused to the plaintiff in respect of his professional life on account of illegal actions of the defendants calculated at rupees 1 lakh per month for the period from so-and-so. 2, loss caused to the plaintiff both mentally and physically on account of so-and-so. Loss caused to the plaintiff on account of breach of contract calculated in the following manner: rate as per square feet as on the date of agreement 930 per square feet for the ground floor. Present rate is 1,850, so difference is 920 per square feet as on the day of the filing of the suit. So that is how we arrived at the figure of 40 lakhs, 25 lakhs 70,000 was claimed under the head of damages, and the remaining 14 was 12 plus the interest.
How has that aspect been dealt with in the order?
No, Malad, that is why we have filed the cross objection. That aspect has not been dealt with at all. The court assumed that the learned trial court assumed that so long as we refund, that's the end of the matter. So perhaps section 56 was lost sight of.
Yes.
So of course that the calculation of damages, I leave it to your lordship because there's no hard and fast rule. We had the basic formula that we had adopted is it was a scheme in the scheme of things. There was plan for a sort of a doctor's chamber. So now that cannot happen with as much facilities as was thought of. And secondly, the difference, the price escalation that has now happened. Because at that point of time, it was 950 per square feet. According to us, it has now risen to 1850. So that balance of that escalation of 920 should be awarded to that. Of course, we've added other mental agony, etc. But whatever be it, I believe that some compensation was warranted in the case because in the cross-examination it transpires, his conduct was not clean. He knew about he ought to know even otherwise. It's a very famous real estate company. And conduct, it's a 2008 till 2008, it was dragged on. Payments were still received, Malad. 2010, we filed the suit, Malad. Then they went as far as even disputing the amount that we had actually paid, Malad, for which we had individual receipts, Malad. To argue on conduct, Malad, if I club in the other matter, Malad, there, at least there was no dispute, Malad. The flat was ready. We had paid the amount. That at least could have been handed over to the wife, Malad. That also they did not do. Instead, they filed an appeal saying again non-joinder technical pleas. The flat was complete in 2008 and today we are in 26, my lord. God knows how, in what condition the flat is. It is still locked in their custody, my lord. We will perhaps need a huge sum to renovate and make it livable today. Unless, of course, they've allotted it to someone else, which I trust they have not.
In that case, what is the order?
That case, they said specific performance, you hand over the flat. But there again, we have a cross objection. I mean, that alone will not suffice because you have to compensate for the delay. Why did you drag it? 2008, it was clear. Because of this dispute with the husband so far as the ground floor is concerned, they did not even hand over the first floor. Perhaps to keep me hostage, that you give up your claim, then you can at least have one flat. And that was an open and shut case. I mean, there was no dispute that that flat was existing, Malad. That flat was existing. They could have handed it over. They again raised disputes regarding quantum, whatever be it, Malad. At least they could have given me the flat, whatever difference of the amount, if there is some inconsistency, that could have been worked out. But why did you hold me hostage and keep the other flat also blocked, Malad?
Yes.
As far as my reply to the counter objection is concerned, question of knowing is addressed in the defendant number 3's cross-examination, particular point of time, title 86 of 2010. Defendant number 3 was the then director. He's a relative who introduced him to the other defendants. Let me read that particular part. On oath, W3 cross-examination of Utpal Das, DW3, taken on 29/9/2014. Although I'm in the business of real estate, I'm in the business of real estate for almost 20 years. I had introduced the plaintiff to the defendant number 2. At that time, when I had introduced the plaintiff to the defendant number 2, piling was going on in the building. The building was under construction. I cannot say as to whether there was any allotment made in under a person at the time when the plaintiff and his wife were allotted the plot. It is my evidence affidavit that after introducing the plaintiff and his wife to defendant number 2, I had nothing to do with the transaction between the plaintiff and his wife and the defendant number 2. So even in the pleadings also, it is before the allotment date. First time I had read before Lordship that the defendant for the first time had met the plaintiff, defendant number 2 had met the plaintiff on a particular date, which I'll produce before. But leaving aside the point of when they had met, the defendant number 2, when and at that time was he aware and should he have apprised? The objection, in the suit, the paragraph 31, 28, the page paragraphs 20, yes, 28, 29, 30, where the claim for damages, etc., has been raised. First part is, I'll just read bits and pieces. I'll raise my objections. Action of the defendant in duping the plaintiff. There's a claim of duping the plaintiff to set up, in respect to the schedule area, have made the plans of the plaintiff to set up a doctor's clinic impossible, thereby causing huge financial losses to the plaintiff. Point 1. Now, there is no exhibit of any design plans for a doctor's clinic. If at the time it is set up to be a doctor's clinic, this is their claim. This is not my claim. The plaintiff has to prove their claim. They say there is a doctor's clinic. It cannot be a vague, airy-fairy intention, I'll set up a clinic. There has to be a particular design. Just like in an apartment complex, there is a design. A design gives an idea of the cost overlay works to be done in respect of the apartment building. Therefore, if I have to make a amphitheater, I need a design. Otherwise, I have no idea of what is going to cost me. There is no design plan exhibited on their part, saying that this is the intent, this is my intent, whereby I intended to create a doctor's clinic. This intent has been frustrated. That would aid your lordship as well as the trial court in arriving at a conclusion as to what exactly was frustrated. What was the plan, intent, design being frustrated? Secondly, the action of the defendants amount to breach of a contract for which the plaintiff is entitled to special damages as well as general damages. What is the contract being breached? The contract is for transfer of 1,000 square feet of. Now, by necessary implication or by implied conduct of the parties, I extend it to say that there was an intent to create a doctor's clinic. The intent to create a doctor's clinic was a unilateral intent of the plaintiff. We had not consented to create the doctor's clinic. We had not consented to design the doctor's clinic. We had not made any assurances that we are going to build a doctor's clinic for you. There was no contract to build a doctor's clinic on behalf of the plaintiff by the defendants. The only possible assurance could have been, we will facilitate the building of the doctor's clinic. Again, for that, the designs are required. Whether that kind of doctor's clinic or commercial space or any kind of establishment was permissible under the statute. So the contract, there is no breach of contract because there was never any contract in the first place to set up a doctor's clinic. Under this particular suit and the statute, my lord is called upon to adjudicate a contract, a breach of contract, whether express or implied. There is no implied contract even to set up a doctor's clinic, no undertaking on my part. Thirdly, the defendants, plaintiff, after realizing the fraud committed by defendants upon him, had inquired with various real estate companies regard to similar areas to the plain, and would come to learn that the present rate is around 1,850 per square feet. This is a square rate being held up in the air. Who are the various real estate companies who have verified this rate? What are the similar areas? What is, as per the master plan, which area, particular area? Is this a commercial area? Is this a semi-commercial area? What exactly is the rate? One particular line mentions that there is a rate which we must accept at face value, that is 1,850 per square feet. My lord, in my submission, this is not the way we evaluate particular valuation of an area or a space. Fourthly, it is further stated herein that the plaintiff had, this is I'm reading from page 32 of their own plaint. It is further stated herein that the plaintiff had invested his hard-earned money to set up the doctor's clinic, and illegal actions of the defendant have, apart from causing mental and physical agony, caused great financial loss. Now, there is no table of investment showing what have the amount invested towards setting up the doctor clinic, the medical equipments, furniture, chairs, the various other if the laboratory equipment are required. What exactly has been incurred? Merely setting up a 4-room and saying that this is a doctor's clinic is not tantamount to incurring investment towards a doctor clinic. A same 4-wall room can be used as a doctor's clinic, it can be used as a residence, it can be used as a hall, it can be used as a marriage venue. And they have to show, not just merely plead, they have to show by way of evidence that their investment has gone towards making a medical establishment, whereby various specific items of medical nature have to be shown as having been purchased. Thereafter, that intent has been frustrated and therefore these investments have gone to vain. That is, my lord, my submission, how to prove that investments have gone down the drain. Merely making an averment will not suffice. Now the table at page 33. Claim has been of 25 lakhs has been subdivided. Again, mental and physical agony, my lord, I cannot counter what has not even been argued as to what mental and physical agony has happened. Again, the rate of, as on the date of the agreement, 930 per square feet of the ground floor area. Present rate has been again arbitrarily taken as 1,850 square feet. Trial court may have considered it, but there was no material on front of the trial court to even accept those kind of rates. Pleadings. Mere pleadings would not suffice. On difference on the rate, on an arbitrary rate and the present date rate agreement, they have come to 9,20,000 figure. Again, my lord, no material documents to show this. 6,50,000 financial loss caused by the plaintiff in respect to his professional life. Where is the averment that the plaintiff has not been able to practice the profession for a particular specified period of 2 years, 3 years? Where is the averment in the pleadings that because of non-setting up of the doctor's clinic, the plaintiff has not been able to set up any other doctor's clinic in any area in Gauhati? These are missing. So therefore, financial losses, maybe financial losses, there may have been a delay, but even then, where is the delay? There is no averment that till date or till for 5 years or 10 years, no doctor's clinic could be set up by the plaintiff. Finally, in paragraph 29, he has stated that here plaintiff has taken 3 lakh loan from the State Bank of India to pay the 12 lakh consideration amount, that is what he has paid. 3 lakh is out of loan. He says 9 lakh has been taken from private persons at an interest of 12% per annum. Possibly, my lord, this is where the learned trial court has come to the finding of 12%. He has taken private loans. Those people, they have not proven how much loan they have given to him. This is again a simple bare averment. Plaintiff is still repaying the amount. Therefore, he has paid a principal amount of 9. The 3 lakhs is provable from the record. State Bank of India has disbursed 3 lakhs to the plaintiff. 9 lakhs from unknown private person and an interest of 12% per annum. No material to show. So in a way, the Honorable Trial Court has granted him some latitude and has considered his predicament in a sympathetic way by granting interest at the rate of 12%.
So you agree he is in a predicament?
He is in a predicament in respect of one plot.
Yes.
In respect of one plot, which in 2009, it was made clear to him that we could not have proceeded further. If as of 2009, we had still proceeded further to mislead him or to do anything that, no, let us proceed further, let us attempt for another round of approaching the GMDA, then maybe the case of duping or fraud could have been made out. Again, my lord will note that letter of February 2009, he has given an assessment of 41 lakhs. This is a case where it is not a case of fraud. It is where the plaintiff desperately desired to set up a doctor's clinic, and for that reason, he was willing to overpay. He was willing to pay more than what was contracted for. It was a case of inducement that get me the NOC by any means possible, and I'm willing to pay through the roof. Possibly, my lord, would my lord like to grant
and
relief?
he became greedy.
it is natural, it is human. As the Lordship has pointed out, this is a very good location, possibly from a medical point of view, also very good location. He said he's willing to overpay. Now, both sides are greedy, admittedly. As a result, is there a relief for greed? If my lord grants the compensatory damages that he has been led down the garden path, the same, as on record, the same does not stand true even as on February 2009. Even prior to that, where he has himself admitted in his pleadings that it is conditional. We may try to get the NOC done. There is no contract. The only contract is to facilitate getting the NOC done. And these are not things to be stated on record as to how an NOC is done in those days, how an NOC was obtained. Maybe he had some hope. Maybe the plaintiff or defendants also had some hope. Maybe the state government did not prove to be capable of bending on this occasion. So both sides had to return home dissatisfied. But to say that this is a case of fraud would be stretching things a bit. And so far, my lord, as in the other case is concerned, I would, because there are certain, the cross-examinations in the other case would also impinge on this case as well. May I be permitted to argue the other case tomorrow also on other date as a continuation of the matter? This case we have substantially covered. Because there are certain confusions in it, because they have again referred to the pleadings and the admissions made in the other suit as well.
We will not make it CAV today itself. We'll keep it for
Your Lordship will keep it as part heard.
part heard. Okay, because other is to be heard. Heard in part. List again on date.
We'll also forget by this time. Can it be earlier than that? 26th if possible. Thursday. It's a Thursday.
6th.
2nd or 3rd of March? March 2nd, 3rd March. Good morning.
First week of DD.
5th March.
5th March.
Obliged.
According to
Yes.
পাঠ করে চলবো আপনি তাই বলে Yes.
Here I am appearing for respondent number 1, my lord. For the appellant, learned senior counsel Vidas is there. If Lordship permits me, I can call him. Is for the appellant, my lord.
We have no other matter, I think.
For 20.
I'll wait for you here to call them. This is a challenge to what? Award.
What they have come for enhancement of compensation.
Then this could have gone for mediation also.
Subject to approval by appellant side, my lord.
The amount awarded,
So the amount awarded was, my lord, 4,29,780. Jury case, my lord.
is the fault in the calculation, anything is pointed out?
My lord, the basic contention is that my lord, the loss of earning capacity, my lord. According to the appellant, the loss of earning capacity has assessed at the lower side. Percentage of loss of earning.
What was the
capacity.
profession?
He was a painter, claimed to be a painter, my lord.
What is the disability?
Disability 45%, but he has suffered fracture injury, my lord.
Of the hand,
My lord, femur, my lord.
femur.
Femur. Kindly see. Case
But
number-
femur, yeah. But the fracture did not heal, the operation did not take place.
Wait, Lordship, may kindly allow to call my senior.
Call, where is it? Has the awarded amount been deposited?
So for that, the instruction, sorry, my lord, because the legal officer, my lord, I could not contact him because his father expired, my lord. Last week, my lord, he is in native place. There was no other legal officer, my lord, a small office, my lord, at Gauhati, my lord.
Your challenge is on the computation of loss of income. He was a painter.
He is a painter, 22 years. Now the Supreme Court judgment has already come. It has given very nice judgment, encompassing all the.
Injury was suffered on the leg.
No, hand.
Huh? Hand.
He cannot lift his hand. I'll take only few minutes, my lord. I'll just say he is 22 years and he is a painter. And your lordship will kindly see, read from paragraph 9 of the judgment. May I read now?
Yes.
On the medical evidence submitted by the claimant, particularly Exhibit 2 and 3, it appears that after accident, claimant had mainly taken treatment from downtown hospital Gauhati for 2 terms with 12 days and 4 days of hospitalization with effect from so and so and so and so.
Both leg and hand. Femur
Leg
is
and
there.
hand. Now he cannot move his hand. I've got a photograph. Yeah. The Exhibit 2 picture certificate reveals that claimant has sustained fractures of the left right femur along with intercondylar fracture of right humerus and fracture of left lateral 1/3 of clevis bone. The treatments provided, so ultimately it is 45%. Paragraph 38, as per the doctor's medical report, in the middle, but better to establish Exhibit 129 suggests, middle portion, my lord, that claimant has been diagnosed as having 45% locomotor disability due to post-traumatic right femur shaft fracture with fracture of intercondylar along with right femurs. So, but this was not accepted by the court below, and it has reduced to 7% without taking into consideration his not position, my lord, physically, which is must as per the of a Supreme Court, which I will place before option. So now the page 41, this is what has been done. Monthly income 4,000. Compensation has been decided in this manner, and his medical expenses has been taken into 3,34,000, and damage for pain and suffering and trauma 35,000. Total 4,29,000. My lord, may I just place one photo? Didi, photo kotha. Your lordship may kindly see his photograph. Huh? Maybe. Leg and all, it is all right. But here in the hands, those rods are still there, and he cannot lift his hand. This physical thing. And like here, if your lordship goes into, this is a case where 8 years old my lord met with an accident, paragraph 3, and the tribunal granted an amount of rupees 3,90,000, paragraph 4. High Court enhanced it to 8,65,000, paragraph 5 and 8. Paragraph 9, my lord, child was minor and minimum wages applicable for skilled worker has been taken into consideration as per the Gujarat government's notification. This has been taken into consideration. In respect of the present petitioner, it will be around 10,500 as per the Government of Assam notification. Let's see. Paragraph 11, my lord, that High Court quantified the permanent functional disability at 90%. This Supreme Court accepted. And paragraph 12 and 13, this is the compensation awarded. And yes.
Calculation.
So monthly income, in our case, we have given a chart. This one. We take into consideration the apex court judgment, the calculation, if we take into consideration 45% physical disability and his monthly income as per the government notification for that wage, as per the government of Assam notification, then the amount comes to that figure. You answer to one amount to? Government of Assam's notification, your lordship will get it at flex C. Skill labor match comes to 10,500. Gujarat government, it was 6,836.
Where is the notification?
Flexi. That bunch. Categories of employers, workers. Flexi. Skill, my lord, number 2. 10,500. Bunch of judgment I have given, my lord.
Have you given him a copy of the calculation?
Yeah, calculation.
Yes, online, yes.
Went on notification. It's a flexibly. Flexi of what, the record?
No,
Your petition.
bunch I have given for the judgment, including judgment. This is Government of Assam notification as per Minimum Wages Act. Below my lord, categories of employees, workers, skill
10,500.
10,500. So I have taken that into consideration. Others will come as per the Supreme Court judgment. And that the learned tribunal, my lord, she has did not believe that report of the medical officer and reduce that physical disability from 45 to 7%. In that regard, like B of the judgment, paragraph 9. Allows, I can just read that. I read that, my lord. How compensation in case where permanent disability of an injured affects his functional disability is to be assessed has been considered by this court repeatedly. Reference can be made to the judgment of so and so. Injured was working as a cart puller. As a result of the accident, his left leg was amputed. His permanent disability was assessed at 60%. The tribunal assessed the compensation taking the loss of earnings 50% on the theory that he can still do some other work while sitting. The High Court did not disturb the finding regarding loss of income on account of disability. This court found that the tribunal was in error in taking the loss of earning at 50% as the injured was 55 years of age, and it may be difficult for him to find a job at that stage. In fact, any physical disability resulting from an accident has to be adjudged with reference to the nature of the work being performed by the person who suffered disability. The same injuries suffered by two different persons may affect them in different ways. Loss of leg by a farmer or a rickshaw puller may be end of the road as far as his earning capacity is concerned. Whereas in case of the persons engaged in some kind of desk work in office, loss of leg may effect. So tribunal has assessed it at 100%. So that has been accepted by the Supreme Court finally. Paragraph 10. So in this case also, my lord, I am not going that 100%, but his one leg, my lord, I find he cannot work any painting work. Therefore, there was no reason for disturbing the finding of the medical court, which says, my lord, he is physical disability at 45%. On that basis.
What was the other evidence regarding his disability, the medical that he could not do work? Any evidence has been laid in that respect?
Cannot do any work, my lord. I'll
Why has the tribunal disagreed with the
tribunal, my lord,
medical evidence?
That he has written, my lord.
Is having 45% locomotor disability due to right femur shaft fracture with fracture of
Para 12. Para 12
effect of such disability.
Painter and disability would have a bearing on his working abilities, as he would find it difficult to reach the extremities of a particular wall with his disabled hand. Claimant neither in the claim petition nor in his evidence has clearly mentioned about such disabilities. On oral assessment, it is considered that it would be reduced by 6-7%, and for it 7% of disability loss of future. But it reveals that injured was 22 years old person. As such, the multiplicable would be 18, but the income has not been established. An amount of rupees 4,000. The duty of the court below to find out is his physical position and what.
The tribunal on observation of the claimant himself during cross-examination, noticing his movement has assessed the claim, the extent of disability. Yes, respondent, what is your?
Paragraph A, page 18, your lordship condition.
Paragraph?
Page 18 of the written evidence on affidavit by the claimant. Page 18, second paragraph from top. That before accident, I was a painter and taken the orders of public to provide paints, color to their houses, buildings, etc. And from the said source of profession, I earn at least rupees 6,000 per month. But after the accident, due to my permanent disability, I have lost my job and became dependent upon my poor parents. In fact, he is dependent on his parents and brothers and all. I've shown the photographs. He cannot lift and he cannot paint. So therefore, the 2023 judgment which I have shown, tribunal's award was not correct because what is required to be taken into consideration, what has happened due to the accident. This has to be found out by the court. Supreme Court says, in fact, any physical disability resulting from an accident has to be judged with reference to the nature of the work being performed by the person who suffered disability. The nature of the work is taken into consideration, it comes to 100% only because he cannot paint. But since the medical report is there 45%, it cannot have been disturbed.
But it is the observation of the court that he can move his hand, only that he cannot fully straighten it.
Therefore, he cannot paint it, my lord. I have shown the photograph now, which was taken yesterday. He cannot paint it. He lost his earning, my lord, his capacity by 100%. If you go by Supreme Court judgment, my lord, it depends upon from work to work and disability to disability. And in the present case, as he is a painter and he cannot move his hand straight, he cannot paint. Even then, since doctor has given 45% disability report, you have to accept that only and go ahead. Rest of the calculation is based on my Supreme Court judgment. It has encompassed all the judgments. That accident took place in the year 2012. That judgment which I have provided at flag A Was also a minor, 12 years, 8 years. Accident took place, I think, in the year 2012. Where initially tribunal awarded about 3,90,000 and by the High Court at 8,65,000. Supreme Court had announced to about 35 lakhs or so. Taking into consideration, all these other factors have not been taken into consideration by tribunal. Right. What was? What was it? Yes. My friend has also made a calculation on 7%, which I don't want to place it. That's not my submission, but for the purpose of original report.
On 7%.
We have calculated taking into consideration physical disability at 7%, but which is not my submission. My submission is 45% is, I'm just for the purpose of the court.
7% has already been calculated by the tribunal.
No, but so many other factors have not been taken into consideration. Monthly income. Monthly income has been taken at 4,000. That is not the law, my lord. Law is basis of the skill level. Minimum wages of the skill level, which is 10,500. At that point of time in Gujarat, it was 6,800 something. So yearly income is so and so. Future prospect is this. Second, multiplier factor is 18. There is no harm. Permanent disability is 45% I have taken into consideration. And loss of future income will have to take into consideration. But we have taken into consideration Supreme Court judgment. Medical expenses, they have given already. But pain and sufferings has not been taken into consideration.
On other aspects, I think as per your calculation and as per the Supreme Court judgments, there is no dispute regarding income and everything. It is only on the point of the
future medical
disability that is a little bit, I think, because of the observation of the court.
Yes. Which is not correct, I must say. The person cannot move his hand, my lord. How can it be 7%, my lord? He lost all his earning. And the statement he has already said, I am dependent on my parents now. So therefore, my lord, I submit, my lord, your lordship will take into consideration. Supreme Court judgment, the recent judgment has taken into consideration all the other judgments of the court.
Why 7%? Why not 10%? That
No, I'm
discussion is
yes,
not there.
there
In
is no
fact,
reason.
how the figure of 7% has been arrived at, that also should have some basis.
It's not.
Maybe 7%, but on what basis?
45% diluting for I'm not there even on the basis of the my lord present physical condition. As per the Supreme Court judgment, it is 100%. I am not going there because he is unable to work. His painting job is gone.
Yes.
May it please your lordship. So called, my lord, the draft that has been placed before your lordship My objection is that that may not be taken on record because this is not the mode of placing the photograph, my lord. That may not be taken on record, my lord, first of all. Now, the second thing, my lord, regarding my lord, the monthly income of the injured, my lord. The pleading and the evidence has been static that his income has been 6,000, my lord. And even the ground today set forth in the memo of appeal, my lord, lordship may kindly see the page number 7 of the ground of appeal, my lord. My learned senior friend is pressing on the notification, but in the ground of appeal, my lord, there is no such ground taken by the appellant side that the income has to be based on that notification, that on the basis of minimum wage prevalent on that particular relevant time, my lord. Only contention is that why not 6,000, since it has been averred and pleaded that 6,000 had to be taken or to have been taken by the learned member. Learned member took 4,000 rupees as monthly income of the injured, my lord. So on that count, my lord, the acceptance of notification, this should amount to a fresh ground, my lord, which is not pleaded in the ground of appeal, my lord. So the learned member, having seen that there has been no evidence as to the income of the claimant, my lord, and there has been no document to show that he was a painter by this evocation, that is why the learned member took 4,000 rupees as monthly income, my lord. So that is there, my lord. Now, my lord, regarding the assessment of disability, lordship may kindly see.
What document will a painter have?
My lord.
What document will a painter have?
Yes, my lord. It is true, my lord. We cannot expect that working, he's a self-employed person. We cannot be expected to any document to be placed by the claimant side. But at least there should have been some other evidence by some other person that he was working as a painter or any.
Did you dispute that in your cross-examination?
Have contested.
Cross-examination, he says, I was a painter by profession, and before that I used to do painting works in buildings. In cross, it is confirmed that he was a painter. There is no suggestion that he is not a painter.
My lord, that is there, my lord, of course, that is there. But I'm submitting on the income part, my lord. Since there has been a clear averment by the claimant side that his income has been 6,000 per month. So
that is also not denied in cross-examination.
That is not denied, my lord.
So you can take it as 6,000 at least.
6,000. That is not denied, but the regarding the basing the monthly income on the basis of this notification is not. I'm not on that, my lord, because the notification there has been no averment in the appeal that monthly income has to be based on the notification, my lord.
What about the judgment of the Supreme Court?
Getting my lord, monthly income, my lord.
Yes.
Well, their stand is 6,000, my lord. Their stand has been 6,000. And even in appeal also, stand is 6,000, my lord. Now, my lord, coming to the question of loss of earning capacity, my lord, lordship may kindly see page 22 of the memo of appeal, my lord. Page 22. This is the disability certificate, my lord, that was produced before the learned member, my lord. Relevant page would be, my lord, page number 23.
Yes.
Lordship may would like to see clause C. He has 45% disability in relation to his part of the body, my lord, that is left kept blank, my lord. So this disability is restricted to that particular limb concerned, my lord. which is described in clause B. Post-traumatic femur shaft fracture, intercondylar fracture, humerus, and fracture of right elbow, shifting. This disability, Lordship, is restricted to that particular limb only.
Yes, that is what he is
Yes.
claiming.
Yes, my lord. Yes, my lord. Now, my lord, Lordship would kindly see how why 7% was arrived at, my lord. Lordship has already pointed out. Lordship might kindly see page number 38. Page number 38 of the memo of appeal, my lord. I'll start from top, my lord. Page number 38. Second line, my lord. Page number 38. Out of 3 injuries, reconstruction of elbow appears to be the major injury. Exhibit 3 reveals that the implants done have been removed from right elbow of the claimant. It is claimed by the claimant that he had suffered permanent disability and also submitted disability certificate issued by the District Social Welfare Department, Borpeta, Assam as Exhibit 129. Claimant also adduced evidence of the Joint Director of Health Services, Borpeta, to establish Exhibit 129 suggests that the claimant has been diagnosed as having 45% locomotor disability due to post-traumatic right femur shaft fracture with fracture of intercondylar along with the right humerus and comminuted fracture of the right elbow. The Joint Director of Health Services, Borpeta, Dr. S.K. Sharma, in his evidence while adducing also stated that said injuries and the disability of the claimant diagnosed and assessed by the District Medical Board, Borpeta, on 18/7/2016. But Dr. Sharma did not point out and elaborate as to the effect of such disability on the working stroke earning capacity of the claimant. Number 10, my lord. It is noteworthy that as per rules, a disability certificate must find specific mention regarding the body part for which the disability has been computed figured. In the present case, the same is not there in Exhibit 129. From the injuries, it appears that disability, if any, had been suffered by the claimant on his right elbow. This is the observation, madam. During evidence cross-examination, it has been noticed that claimant's elbow has a restricted movement and the forearm does not straighten due to such restricted movement. The other joints is number 39, my lord. The other joints of the hand are working normally. This is the observation made by the learned tribunal, my lord. Now, to compute the compensation damages which the claimant would be entitled to, it is important to figure out as to what extent the disability of the claimant, as pointed out by the Joint Director of Health Services, Borpeta, had caused loss of his earning or future earning capacity. Learned counsel for the claimant, while advancing his argument, also relied on certain judgments rendered by the Honorable Apex Court in various cases. Now, my lord, the disability of 40%, 45% is in relation to that particular limb, my lord. Now, the learned member, what he was to do, my lord, he was to find out the loss of earning capacity due to that disability. It is not the disability which has to be taken into account for computing the compensation, my lord, but the loss of earning capacity due to that disability. And once the disability is assessed in respect of a particular limb, my lord, then the whole body disability has to be assessed. Whole body. How the disability of that particular limb would affect the earning capacity, taking into account of the whole body disability, my lord. That has been the law, my lord. In that respect, my lord, I would like to rely upon the judgment of Ajoy Kumar versus Rajkumar, my lord.
But where is that assessment?
Yes, my lord. I am placing the judgment, my lord. Is there, my lord. How to assess the loss of earning capacity. I have highlighted, my lord, para 7, my lord. I'm reading, my lord. The percentage of permanent disability is expressed by the doctors with reference to whole body, or more often than not, with reference to a particular limb. When a disability certificate states that the injured has suffered permanent disability to an extent of 45% of the left lower limb, it is not the same as 45% disability with reference to whole body. The extent of disability of a limb or a part of body expressed in terms of a percentage of the total functions of that limb obviously cannot be assumed to be the extent of disability of the whole body. Obviously cannot be assumed to be the extent of disability of the whole body. If there is 60% permanent disability of the right hand and 80% permanent disability of the left leg, it doesn't mean that the extent of permanent disability with reference to whole body is 140. That is 80% plus 60%. If different parts of the body have suffered different percentages of disabilities, the sum total thereof expressed in terms of the permanent disability with reference to the whole body cannot obviously exceed 100%. Number 8, where a claimant suffers a permanent disability as a result of injuries, the assessment of compensation under the head of loss of future earnings would depend upon the effect and impact of such permanent disability on his earning capacity. So that is why, my lord, the loss of earning capacity had to be assessed, had to be taken out from the disability, my lord. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of economic loss, that is the percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Some tribunals wrongly assume that in all cases a particular percentage of permanent disability would result in a corresponding loss of earning capacity, and consequently, if the evidence produced show 45% as the permanent disability, will hold that there is 45% loss of earning capacity. In most of the cases, equating the extent percentage of the loss of earning capacity to the extent percentage of permanent disability will result in award of either too low or too high a compensation. What requires to be assessed by the tribunal is the effect of the permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of percentage of income, it has to be quantified in terms of money to arrive at the future loss of earnings by applying the standard multiplier method used to determine loss of dependency. We may, however, note that in some cases, on appreciation of evidence and assessment, the tribunal may find that the percentage of loss of earning capacity as a result of permanent disability is approximately the same as the percentage of permanent disability, in which case, of course, the tribunal will adopt the said percentage of determination of compensation. Now, my lord, this is a case of fracture, my lord. This is not a case of amputation. So, lordship, the learned tribunal, while seeing the injured person during cross-examination, clearly held that he could move his hand and other organs are working smoothly. That is why, my lord, I'm not saying that 7% loss of earning capacity is not so properly assessed, my lord. I'm not also saying that, but the loss of earning capacity, according to he found that loss of earning capacity could be only 7%, because seeing the condition of the injured person during his cross-examination, my lord, and because the loss of disability is not which is to be assessed for assessing computing compensation, my lord, but the loss of earning capacity due to that disability. That has been expressed by the Honorable Apex Court in this judgment, my lord. This is widely accepted judgment, my lord, and relied upon, my lord. Now, my lord, para 9, my lord, finally, my lord. Therefore, the tribunal has to first decide whether there is any permanent disability, and if so, the extent of permanent disability. This means the tribunal should consider and decide with reference to the evidence whether the disablement is permanent or temporary. If the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. If the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But if the tribunal concludes that there is permanent disability, then it will proceed to ascertain its extent. After the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence, it has to determine whether such permanent disability has affected or will affect his earning capacity. That has been done, my lord, by the tribunal, my lord. Because the learned member saw the injured person during cross-examination, found that all the organs are working properly. That is why, my lord, 7% has been quantified, my lord, as a loss of earning capacity, my lord. Now, my lord, again, my lord, my learned senior friend has related upon a judgment of minor girl. That is a case of paraplegia, my lord. Completely paralysis girl, my lord. But this is not the case. This is a case of fracture only. The facts are totally different, my lord. It's a case of paraplegia. That minor girl, my lord. Sir.
Yes.
That is my humble submission, my lord.
There are only 1 minute. You have that flag A, my lord. Flag A, if your lordship takes into consideration. Paragraph 3. It was a petition claiming 10 lakhs rupees. So even in a petition, if I claim 5 lakhs rupees, all the legal aspects are taken into consideration.
That is settled.
It's settled position of law. And if your lordship goes into that Ojoy, what is Ojoy case, my lord, paragraph 7, 8, and 9, your lordship will include. But in that regard, my lord, 24 Supreme Court, that flag as Supreme Court has already, my lord, stated how the disability has to be taken into account. Painter, my lord, and he cannot paint. Whether that has been taken into consideration when determining or bringing down his physical disability from 7%, that whether he can paint or not. That aspect of the matter has not been found out or discussed by the tribunal. So in that view of the matter, I state, my lord, that there is no reason for even this physical disability has not been ascertained properly. Ascertained properly, I am sure, my lord, because
Then what, remand?
my lord,
Remand.
not remand.
If it is to be ascertained properly.
No, no. Basically, I'm just making a submission.
All right, save.
Right.